Good afternoon, Senior Minister of State of Singapore's Ministry of Law and Finance, Ms. Indrani Raja, SIAC Court President, Mr. Gary Bond, SIAC Court and Board members, ladies and gentlemen. Welcome to the SIAC India Conference. To our international guests, a very warm welcome to Delhi. On behalf of Singapore International Arbitration Center, I would like to thank you for joining us today. We are indeed very pleased to have the pleasure of your company. My name is Pranab Mago, and I'm your host for today. The theme for today's conference is crystal ball gazing into the future of international arbitration in India. Our panelists today include distinguished and august members of the international arbitration community who will be sharing their views with us today. Without further ado, I would like to invite Ms. Lim Seok Hui, CEO of SIAC, to give us a welcome address. Ms. Lim Seok Hui.
Senior Minister of State of Singapore's Ministry of Law and Finance, Ms. Indrani Raja, SC, His Excellency the High Commissioner of Singapore, Mr. Gary Bond, Board and Court members who are present here with us today, ladies and gentlemen, good afternoon and welcome to the SIAC India Conference 2017. A special thank you to SMS Indrani for gracing this event. And may I say, what an amazing and elegant sari you're in, as ever. This event would not have been possible without the generosity of our sponsors, and I thank you all for your support. And last, and most importantly, thank you to all of you here for taking the time from your busy schedules to join us at this event. The theme of today's conference is crystal ball gazing into the future of international arbitration in India. Judging by the number of delegates in attendance, it would appear there are many stakeholders who feel united by the common goal of charting the correct course for arbitration in India. The first step in this evolution was the recent amendments to India's Arbitration and Conciliation Act. Looking beyond just the provisions, the updated Act shows the government's broad commitment to providing an effective dispute resolution mechanism and shows that Indian users place a high priority on time and cost efficiencies in an arbitration. All this augurs well for India's move to the global standard of institutional arbitration. Whilst India has historically shown a preference for ad hoc arbitration, there is now a growing impetus towards institutional arbitration. The recent pro-arbitration judgments in the Indian courts show strong support from the bench for the arbitral process. These are all steps in the right direction, and now is a truly exciting time for arbitration in India. India's commitment to establishing a robust arbitration framework fits perfectly with the remarkable growth of the Indian economy. India is expected to be a $6 trillion economy, the third largest in the world in the next 10 years. The Indian government has also introduced progressive initiatives such as Make in India and the Asia-Africa Growth Corridor to provide a framework for the increased integration of India into the global economy. With a consequent increase of foreign direct investment into India, the Indian presence at SIAC stands to increase even further across an even broader range of disputes. Just taking 2016 by way of an example, we saw 153 Indian parties in SIAC arbitrations across a range of sectors, including corporate, commercial, international trade, major projects, and intellectual property. In addition to traditional centers such as New Delhi, Mumbai, and Bangalore, we are also starting to see disputes from other Indian cities like Ahmedabad, Chennai, Kolkata, and Hyderabad. It is for these reasons that SIAC recently opened its second office in GIFT City in Gujarat. This office, together with our existing representative office in Mumbai, will allow us to serve our Indian users better and will deepen SIAC's existing ties with the legal and business communities in India. Indian users have contributed significantly to the success of SIAC. Over the past 5 years, Indian parties have featured consistently within our top 3 foreign users. In fact, in 2013, 2015, and 2016, India was our top foreign user. In keeping with the theme of looking to the future today, I'm also happy to share that this year, Indian parties continue to top SIAC's foreign user rankings. These results underscore SIAC's continued commitment to ensure that we stay focused and responsive to the needs of Indian users. Perhaps it should come as no surprise to those of you who are familiar with Singapore and SIAC that Indian users like to come to Singapore and for SIAC cases. Singapore and India share a common law system and are connected by many long-standing cultural, familial, and commercial links. The close proximity and connectivity between the two countries means that an Indian party and its counsel could fly to Singapore on any of the dozens of direct daily flights, seek advice from a Singapore firm or an international firm as co-counsel, attend a hearing at Maxwell Chambers, the world's first purpose-built dispute resolution complex hearing facility, and then adjourn for some of the best Indian food outside of the subcontinent at the end of the day. Indian parties are a natural and easy fit in Singapore, and it is for this reason that Indian parties will sometimes even choose to arbitrate their domestic disputes at SIAC. SIAC shares India's commitment to resolving disputes expeditiously. Our goal and our overall mission is to provide efficient, effective, and economically reasonable case management services. The costs and duration study we released last year in October 2016 showed that the median duration of cases before a sole arbitrator was 11.3 months, and before a 3-member tribunal was 11.7 months, in both cases under 12 months. We are not just, therefore, a premier global arbitral institution with one of the highest administered caseloads in the world, but also, as the costs and duration study suggests, faster and more cost competitive than other major institutions. At last year's conferences in Delhi and Mumbai, we introduced our then newly minted SIAC 2016 rules. A year or so down the road, we've seen many consolidation applications under the new rules, even more expedited procedure and emergency arbitrator cases under the enhanced new provisions. And interestingly, for the first time, several early dismissal applications for both claims as well as defenses and counterclaims. With the delocalization of the seat in the 2016 rules, Singapore is no longer the default seat, and parties can choose to have both the legal seat and the hearing venue in India, and to have the arbitration administered by SIAC under the SIAC rules. Despite this, Singapore remains the most popular seat, even for Indian parties, in SIAC cases. Our latest offering, the investment arbitration rules, which were introduced on 1st January this year, are We are the first commercial arbitral institution in the world to introduce a separate set, a standalone set of rules to address the special features and demands of arbitration proceedings involving states, state-controlled entities, and intergovernmental organizations. In the context of India's renegotiation of many of its bilateral investment treaties, we hope this set of rules will be useful in helping parties resolve these types of disputes. This is the present for SIAC and, of course, India, and it's time now to discuss the future. I hope you will enjoy today's conference and will stay with us for this evening's hard talk. Please allow me now to hand the floor to SMS Indrani for her special address. Thank you.
Mr. Gary Vaughan, President of the SIAC Court of Arbitration, members of the SIAC Board and Court, Ms. Lim Seok Hui, CEO of SIAC, distinguished guests, ladies and gentlemen, Namaste. I'm delighted to be with you here today in Delhi at SIAC's India Conference. We have in this room today representatives from among the best in India's and the international arbitration community, and I'm very honored to have this opportunity to address you. The conference theme this year is a very apt one: crystal ball gazing into the future of international arbitration in India. I will share what I see in the crystal ball in a little while, but before that, it would be helpful to consider a few facts and trends. The center of gravity of global economic growth is already in Asia. The International Monetary Fund projects that Asia will account for almost 40% of global GDP this year, compared to 31% a decade ago. It remains the fastest growing region in the world. India, along with China, is leading the growth of Asia. The World Bank expects India to grow by 7.2% this fiscal year. This is remarkable. This is undoubtedly driven by Prime Minister Narendra Modi's commitment to transform India. There have been impressive changes, such as the implementation of the world's first digital and biometric identification infrastructure, Aadhaar. More than 1 billion have been enrolled under this scheme. What does India's growth mean for its people and companies? It means the following: people's lives will be uplifted. A study by the Brookings Institute shows that India will contribute 380 million people to the global middle class by 2022, the world's largest contributor. It means urbanization, with cities increasingly powered by smart technology. The United Nations estimated that in 2016, there were 2,016 megacities in the world, with 6 in India alone. New Delhi is one of them. This will drive demand for urban solutions and infrastructure. McKinsey estimates that the demand in this sector will grow by US 20 trillion between 2016 and 2020, with China and South Asia accounting for a large part of it. Companies will grow, diversify, and venture abroad as they expand. With India's growth, Singapore now has a strong contingent of over 7,000 Indian companies. Many use Singapore as a springboard to access opportunities in the rest of Asia and beyond. Indian companies in Singapore will come from all sectors. They include Tata Steel, that's India's largest steel manufacturer, Wipro, India's second largest IT services company, and Apollo Tyres, India's second largest tire company, and many other companies from a very wide range of sectors and of all sizes. In short, there will be a multitude of new opportunities, not just for India, but for your partners. The strong and warm bilateral relationship between India and Singapore exemplifies this. Our bilateral relations have grown over the years. Prime Minister Modi and our Prime Minister, Lee Hsien Loong, signed the India-Singapore Strategic Partnership in 2015. We share strong economic ties anchored by the Comprehensive Economic Cooperation Agreement. One project that we are working on together is the development of Andhra Pradesh capital city, Amaravati, an example of our mutually beneficial cooperation. Strong economic cooperation has facilitated strong people-to-people links. India is now Singapore's fourth largest source of tourist arrivals. And greater interaction between our peoples will naturally facilitate more commerce. All this means that there will be more business and more cross-border business for Indian companies and their partners, and that means more cross-border disputes. That is the nature of commerce. The ability to handle disputes properly is an essential consideration in the viability of a business endeavor. Or putting it another way, dispute resolution is an important factor in the bankability of a project. Investors will take into account the mode and mechanisms of dispute resolution before they invest. Indians are no strangers to disputes and dispute resolution. Before the word dispute entered our lexicon, it was already present in the ancient Sanskrit epic, the Mahabharata. Its narrative is replete with scenes of disputes and attempts to resolve them. One such effort involved Lord Krishna's attempt to settle the feud between the Pandavas and the Kauravas, the failure of which led to an epic battle between the two sides. Apart from its many cultural and historical attributes, the Mahabharata is a salutary example of what can happen if you don't have quick, efficient, and decisive means of dispute resolution. The result is a protracted war of attrition with high costs on all sides. And it also highlights something else, which all disputes lawyers know, that the most difficult disputes to resolve are the family disputes. So in short, good dispute resolution is essential. The recent reforms to the Indian Arbitration and Conciliation Act exemplify this. The amendments bring the Act in line with international standards. They reflect a recognition of how fast and effective dispute resolution can support India's growth and the internationalization of its companies. I hear that the changes were warmly welcomed by legal and business communities. At the same time, there has been a growth of arbitral institutions in India. This will boost the popularity of arbitration as a means of resolving disputes, and in particular, the use of institutional arbitration as a neutral and effective method to settle disputes. I'm glad that the SIAC has been part of this growth and that it has been able to offer a reliable and cost-effective option for Indian parties to resolve their cross-border disputes. As Siac mentioned, Indian parties are consistently among SIAC's top 3 users and have been so for the past 7 years. In 2015 and 2016, Indian parties were SIAC's users, with the numbers growing by almost 70%. Over 22% of SIAC's high-value cases are from Indian parties, with sums in dispute of over Singapore dollars 25 million. To better serve Indian users, SIAC opened a Mumbai office in 2013, followed by another office in the Gujarat International Finance Tech or GIFT City in 2016. So what is the future of arbitration? Based on the above facts and trends, the vision the crystal ball holds is pretty clear. The future of arbitration in India is bright. It will be an important part of India's rise and internationalization, and Singapore and the SIAC can facilitate this. As Indian parties enter into more cross-border transactions, there will be increased need for commercial dispute resolution options. Many will be handled in India by the Indian system and institutions. In other cases, parties may wish to resolve their disputes at a third-party venue or institution. Singapore and the SIAC can cater to this need. Singapore is known for its neutrality and as a trusted venue and system. We have a strong reputation for the rule of law. Our legal system is familiar to Indian parties as we share a common law heritage. Today, Singapore is among the top 5 most preferred seats of arbitration globally. Arbitral awards issued in Singapore have the advantage of being enforceable in other signatory states of the New York Convention on the recognition and enforcement of foreign arbitral awards. India is also a party to the convention. We have built up a strong dispute ecosystem that offers a full suite of options for Indian users to pick and choose from according to their needs. You're already familiar with the SIAC, which is among the top 5 most preferred arbitral institutions in the world. It is a truly international institution, with over 80% of its cases having no connection at all with Singapore. It has a large and diverse panel of world-class and reputable arbitrators, including 21 Indian lawyers. Among these are the eminent Rajiv Luthra, Darius Kambata SC, and Harish Salve, all luminaries in the Indian and indeed the international lawyering community. SIAC's costs are competitive for all types of tribunals and sums in dispute. In the Global Arbitration Review's recent publication on arbitration costs compared, SIAC fared well when compared against other international institutions. We have other high-quality institutions should you require other modes of dispute resolution. The Singapore International Mediation Center offers world-class mediation services, and the Singapore International Commercial Court, the first of its kind, hears commercial disputes in litigation, including those which have no connection with Singapore. And when you resolve disputes in Singapore, you have access to a wide range of legal service providers. We have an open regime for the practice of international arbitration. Parties who arbitrate in Singapore can engage lawyers of any nationality. Over half of the top 100 law firms by revenue have a presence in Singapore. Many barristers have also set up offices in Singapore, so there's plenty of choice for counsel. As an international financial and business hub, you will be able to find the necessary experts to provide support for your cases, for example, for valuation, financial modeling for assessment of damages in complex cases, geotechnical and engineering experts, to name just a few. Then there is the world-class infrastructure at Maxwell Chambers, the world's first integrated dispute resolution complex and one of the most preferred hearing centers in the world. Maxwell Chambers will be expanded. We are tripling its size. My ministry has recently taken over the building next door to Maxwell Chambers for refurbishment. The new facilities will be ready by 2019. We aim to make it will be called the Maxwell Chambers Suites. We aim to make this the most user-friendly and conducive arbitration facility in the world. So, if you have ideas on how Maxwell Chambers can be improved to meet your needs even better, please feel free to speak to myself, to the SIAC members, or our staff in the course of this conference. So more generally, I would say that the image in the crystal ball is clear, simply because Singapore and India share many affinities. India's links to Singapore and the region go back to the times of the Cholas. When modern Singapore was founded in 1819 by Sir Stamford Raffles, a thriving Indian community commenced almost immediately thereafter. Since then, we have had successive waves of Indian migration over the 2 centuries, with the last wave being in the mid-2000s. The Indian community is an important part of Singapore's multicultural and multiracial fabric. It has enriched Singapore with its diverse heritage and traditions, and it has transformed and been transformed by Singapore. I hope you will have a chance to visit, if not work, then for leisure. You will feel right at home there. I want to show you a few images from our recently set up Indian Heritage Centre, which was officially opened by Prime Minister Lee Hsien Loong in 2015. That was the year of the 50th anniversary of diplomatic ties between Singapore and India. The centre celebrates the contributions, culture, and traditions of Indians in Singapore and Southeast Asia, and attempts to tell their stories and trace their roots. The gold necklace of Kasumalai, that was the one that I think that flashed up on the screen just now, if I could just ask them to show that. Looks like we're having technical issues here. But in any case, let me press on. You will find that there is Indian art, Indian jewelry in Singapore. You will find that there is Indian architecture. You will find that there are Indian traditions, and most importantly, Indian food. This was the necklace that I mentioned. We could just show this one followed, it belonged to the family of the late Mr. Nana Pragasam Pillai, 1872 to 1915. Mr. Pillai was an early trader. He established a grocery business in Singapore in the early 1900s after moving there from Pondicherry in southern India. He then ordered the necklace to be made in Madras from Chennai for his wife. The necklace is not just an example of superior craftsmanship, but it bears testimony to the heritage and roots of a pioneering Singapore Indian family. Let's see if the next image comes up. Yes, it does. The 19th century Chettinad doorway. This is a late 19th century wooden doorway from Chettinad in Tamil Nadu with thousands of elaborate carvings. The Chettinad region is the origin of the Chettiar business community, who were among the early migrants to Southeast Asia, including Singapore. This doorway speaks of the intimate relations between our two countries and our intertwined histories. I think it is also a fitting symbol of how Singapore can be your partner, the gateway for dispute resolution. There are a few other artifacts in the collection of the Indian Heritage Centre. The painted and carved wooden ceiling from Chettinad, the wooden gable from a house in Kerala, the tiled Islamic facade from Multan. That is from Pakistan, but it also is part of the Indian heritage that we have. And there's the entrance to the Indian Heritage Centre itself, a much more recent piece of work which was commissioned for the purposes of the Heritage Centre, but done in India for Singapore. And of course, don't forget other cultural ties and affinities. Food. There is chili crab. This is one of our favorite national dishes. The food in Delhi is unbeatable, but we have our own creations too. So iconic dishes such as chili crab will give you a taste of something familiar and yet new. It's sweet and spicy all at once, and you will be able to find Indian cuisine that will make you very much at home. If you have particular requests for our new Maxwell sweets, for food choices, do let us know. We'll be able to incorporate that in as well, especially if you're working through lunch and you need tiffin carriers. Just let us know. There's fish head curry. You will find that some of our dishes are familiar yet different. The fish head curry is something which evolved in Singapore. We took the curry from the Indian side. The fish head part of it came from the Chinese side, but it has become a very much beloved Singapore national dish, and all visitors to Singapore have to try it at least once. So let me conclude. To conclude, I'll reiterate the vision. The future of arbitration in India is bright, and there is potential for SIAC and Singapore to work closely with India to realize this vision. With this, I'd like to take the opportunity to wish you all a very productive conference. Thank you very much.
I now call upon Mr. Gary Bond, President, SIAC Court of Arbitration, for the keynote address.
Senior Minister of State, Indrani Raja, Chief Executive Officer, Lim Sak Hui, Mr. High Commissioner, members of the Court and Board of SIAC, Namaste, and to the rest of you, perhaps most importantly, thank you for coming. We at Siac value enormously your support, your participation, and it's wonderful to be back here and see so many familiar faces. I was asked to speak today about crystal ball gazing about arbitration in India. And I confess I still have difficulty coming up with a topic. That's problematic. I'm not sure what I would say about India. I think most of you are probably better qualified than I to speak about arbitration in India. So I thought about crystal ball gazing for international arbitration globally. Siac is a global arbitral institution. And that's a possibility. And focusing on SIAC and our new rules, I thought in particular that I would address you about Rule 5.3 in our Expedited Procedures and its interaction with Article 2, specifically Article 2, subparagraph 1 of the United Nations Convention for the Recognition and Enforcement of Foreign Arbitral Awards. I thought that attention to detail would be something you would all appreciate in this afternoon session here in Delhi. I can see from your blank stares that that's the last thing you want to hear about. You'll be relieved that I'm not going to speak about Rule 5.3 or the New York Convention much. I thought instead that I might talk about television, something that on this sleepy afternoon before Diwali begins might keep our attention and our interest a little bit more. I thought, what television could I speak to you about that might connect to crystal ball gazing about international arbitration? Why not the Game of Thrones? You all know about that, of course, I'm sure. It is set in either the past or the future. It's fantasy. It never really happened. It's about a paradise, in a sense, a beautiful Westeros land where there has been a long, productive, harmonious summer. The fields have been full of fruits and vegetables, food, not quite the food that Senior Minister Niraj Tucker showed you, but still, food filled the tables of the people who had jobs from the bustling markets and commerce. There was peace in the land, mostly. All could not be better. It was a summer with a bright future. But in fact, and this is perhaps what the title of this crystal gazing talk should be, winter might have been coming. In a sense, that's the title of my keynote, Is Winter Coming? Because beyond the borders of this land, there was a wall between Westeros, the harmonious, peaceful fantasy land where people lived harmoniously. The undead were rising. They wanted to tear down the wall, the White Walkers, with dragons reborn. They wanted to destroy the villages and destroy the peace. And you'll have to see episode 8 to understand, season 8, to see how the series in the fantasy world unfolds. But I wonder if, and because this is crystal ball gazing, I can't offer a prescription. I can't offer conclusions. I can only offer concerns, in a sense, hypotheses. I wonder if that analogy, winter is coming, might not apply here. I wonder if, in fact, maybe we should worry about whether the future is so bright. I mean, on the one hand, international arbitration does look like it has never had a brighter moment. Think about it. The New York Convention could only muster 24 signatures 60 years ago or so. Only 24 states would bother to sign it. Numerous states, United States, China, Soviet Union, other states, wouldn't sign the convention, much less accede to it or ratify it. Today, 165 states have acceded to or ratified the convention, 165 states or territories. It has been rightly called the most successful international treaty of all time. It provides a global constitutional framework for international commercial arbitration. Its success has been unparalleled. No state has ever denounced the treaty, and additional states ratify it each year. States have not just voted for arbitration by international arbitration by acceding to the New York Convention. They've also adopted national legislation that supports robustly international arbitration. The UNCITRAL Model Law on International Commercial Arbitration is a good example. It didn't exist in 1984. Today, it has 100 states and territories that have adopted it, including here in India, where, changing historic traditions, a robustly pro-arbitration instrument of legislation was adopted in the 1990s. States have voted with their national laws, as well as with their treaty ratifications, to robustly support international arbitration as a means of efficiently and peacefully solving international disputes. Arbitral institutions have also been founded all around the world, including recently as this year in Mumbai, here at home, but also elsewhere around the world. And perhaps most importantly, users of institutional arbitration, users of arbitration generally, have voted with their arbitration clauses, with their contracts with one another, to use the arbitral process to resolve international commercial disputes. 25 years ago, SIAC had a caseload of less than 5 cases. This year, we will beat 400. The ICC, 25, 30 years ago, had a caseload of a few hundred. They broke 1,000 this year, and who knows what will happen next. Other arbitral institutions have seen similar growth all around the world, reflecting the choices of parties, the choices of commercial parties on how to resolve their international commercial disputes. Caseloads have never been higher because arbitration, international arbitration, has never been more preferred as a means of international dispute resolution. It's not just the number of cases have increased, but the types of cases. Historically, arbitration was thought to be useful only for resolving ordinary contractual disputes, commodities, shipping, those sorts of things. In a sense, SIAC was established with that primarily in mind. Today, arbitration is used to resolve internationally a whole host of disputes, every kind of dispute that one can imagine. Intellectual property, which historically was non-arbitrable, intellectual property disputes are routinely resolved by arbitration. Financial services disputes, the European Bank for Reconstruction and Development includes arbitration clauses in its loan agreements, something which is historically uncommon. Insolvency disputes, historically thought to be non-arbitrable, are increasingly subject to arbitration. In some countries, consumer and employment disputes. In other countries, a number of countries, a global trend in this direction, at least if you look at current caseloads, investment disputes. 60 years ago, states had no treaty, either multilateral or bilateral, for the resolution of claims by foreign investors against host states which took their property. Today, nearly 3,000 bilateral investment treaties, including treaties to which this country and Singapore are parties, provide both substantive protections for foreign investors and procedural mechanisms for resolving those disputes by, not surprisingly, international arbitration. The ICSID Convention, adopted in the 1960s, provides a global framework for investment arbitrations as well. The powers of arbitrators equally have expanded. 60 years ago, arbitrators were thought not able to issue interim relief, not able to impose sanctions on parties who refused to comply with their provisional measures or other orders. Today, arbitrators routinely do that, acting pursuant to national arbitration legislation and the New York Convention, which gives effect to those orders. When you look back at that history, one cannot help but wonder how the future would not be bright. It has been an extraordinary history of success. And it has brought with it as well, it's not solely responsible by any means, not at all, but it has brought with it exactly the objects for which states adopted the New York Convention and the UNCITRAL model law and other national arbitration statutes. Namely, it has provided the oil, the lubricant for international trade, which in turn has provided jobs and prosperity, as well as tax revenues for governments around the world, states around the world. Again, like Westeros in the Game of Thrones, a harmonious, productive, peaceful world. But there are those outside the wall, the army of the undead, who would tear that all down. At least that is a possible hypothesis. International arbitration has, and has particularly had in the last decade, its critics. Critics first, but I emphasize there first, not only, but first, criticized international investment arbitration on a variety of grounds and robustly. Criticized it as secret tribunals, acting confidentially, not transparently, behind closed doors. Tribunals not chosen democratically through a political process, but secretly by large corporations, multinational corporations. Biased, not independent, but biased in favor of investors and against host states. Making rulings not subject to appellate review, necessarily inconsistent, flouting the law, undermining the rule of law, undermining ultimately democracy. Intruding on state regulatory space in the most sensitive areas of national regulatory policy. Those critics, their words, their concerns did not fall on deaf ears. States around the world have, as in this country, reconsidered bilateral investment treaties and dispute resolution provisions. The European Union has announced plans to abandon investment arbitration, to replace it with an investment court. In the United States, just yesterday, in the same vein as all those criticisms, the President announced plans to eliminate investor arbitration in the North American Free Trade Agreement. All those ideas are of a common thread. They come from a common home. But those concerns are not directed only towards investment arbitration. They are directed towards the process of arbitration. They logically can apply just as well, at least in most cases, to international commercial arbitration. Concerns about confidentiality, which, interestingly, have prompted commentators in England to propose revisions to the English Arbitration Act, making arbitrations presumptively transparent, not confidential. Concerns about tribunals not subject to appellate review, apply just as well to commercial arbitration, as Lord Thomas, again in Europe, in England, outlined in a speech proposing heightened judicial scrutiny of arbitral awards. Concerns about the process have been heard equally in the United States, where front-page articles, a series of articles in the New York Times, outlined the procedural failings of the arbitral process. Those critics would come beyond the wall and eliminate much of what has been accomplished over the last 60 years since the New York Convention in 1958. They would replace arbitration with courts, or change radically the relationship between courts and arbitration, thus destroying many of the benefits, perhaps all of the benefits, of the international arbitral process. Everyone looks about as blank now, or at least as sad as when I began with Rule 5.3. I was supposed to tell you about a bright future, and I've painted a dark, ominous, sinister one. What are we to do? Let's think about TV again. The House of Cards. Not exactly the Game of Thrones, but a president full of folk wisdom and catchy phrases. What does he tell us? What does Frank Underwood tell us? He has advice for many. He tells us that there are only two kinds of people in the world: those who hunt and those who are hunted. We in the international arbitration community are being hunted. We should turn the table. We should hunt. Why is it that states have, with their treaty accessions, with their legislation, with their arbitral institutions? Why is it that businesses, with their money, with their arbitration clauses, with their workers, just like states with their taxpayers, have voted for international arbitration over the past 60 years? Why have they done that? Why have they done those things that the critics, those beyond the wall, seek to tear down? They've done them first for the 5 E's, which remain true notwithstanding the criticisms. Arbitration is more expert, more efficient, more expeditious, more even-handed, and more enforceable than the alternatives. And because of those 5 E's, it provides a more durable, reliable means of peaceful dispute resolution. Dispute resolution like that in the Mahabharata, that prevents armed and other conflict. Arbitration is more expert because parties can choose, and arbitral institutions can choose decision makers based upon specific contracts, disputes, and parties. Not one size fits all taken off the judicial shelf. Arbitration is more expeditious and efficient because procedures can be designed for particular parties and particular disputes using innovative methods. Arbitral institutions are innovating every year. Arbitration is more even-handed because instead of dispute resolution in one party's home courts, actually, as we all know, always both parties' home courts, it's conducted in an independent, neutral, objective forum. Arbitration is more enforceable because of the New York Convention and the ICSID Convention. All of those reasons remain true today. And they are reason enough for rejecting the criticisms and turning around against the critics and saying that it is they who would deny justice and undermine the rule of law, not arbitration. But there's another reason. There's another reason, which is that in free democratic societies like this, like India, that place a premium on party autonomy and recognize the freedom of individuals, of businesses to enter into contracts like they enter into marriages or religious associations or civic groups. That those parties not only have the freedom, the autonomy to make relationships, but also to choose how to mend them as relationships inevitably fray and require repair. Arbitration at the end of the day is a recognition of the fundamental right of the citizens to resolve disputes in a manner of their own choosing, just as they enter into relationships of all kinds in a manner of their own choosing. Two historical anecdotes illustrate that. The Constitution of Year One in the French Republic provided among its very first articles that the right of the citizens to resolve disputes by arbitrators of their own choice would not be infringed. A constitutional right, a right reflecting the fundamental importance of dispute resolution, of arbitration to autonomy of individuals. Guess who rejected that? Napoleon, in the Napoleonic Code, who adopted legislation, prescribed, dictated legislation that essentially made agreements to arbitrate unenforceable for a century in France. Similar story in Germany. In the 1860s, the Code of Civil Procedure in Prussia and other German provinces provided a robust pro-arbitration legal framework. It encouraged arbitration, reflecting the same values as in the French Constitution. In the 1930s, the National Socialists in Germany adopted directives providing that arbitration was a threat to the power of the National Socialist state and would not be permitted by state entities and, in the fullness of time, otherwise. That reflected the same underlying philosophy of Napoleon, and to some extent, those who would tear down NAFTA and arbitration more generally. It reflected a philosophy that individuals can't be trusted with choices about how to resolve their disputes, can't be accorded the freedom or the autonomy, the liberty to resolve disputes as they choose. Ultimately, those who would destroy arbitration are the ones who undermine the rule of law, because one of the fundamental objectives of the rule of law is to safeguard those civil rights, those rights of liberty and autonomy that are so precious to all of us. So, when you go out today, remember, don't be hunted, hunt. Thank you.
Thank you, Gary, for a very encouraging message. We will not be hunted, we will hunt. With that, we'll take our first coffee break. I request all of you to please be back at your seats in the next 15 minutes. Thank you very much. As already discussed in the morning, Indian parties are very popular at SIAC, and now with the changed regime, I'm sure we can all do with some expert advice on that. I would like to welcome on stage our moderator for this session, Mr. Stephen Lim, partner, CMS, and our panelists, Mr. Gary Bond, Ms. Elodie Dulac, Mr. Manish Lamba, Mr. Ankim Beg, Mr. S. Ravi Shankar, and Mr. Kabir Singh.
Well, good afternoon, everyone. This is our first panel session, and the topic of our session is successfully managing SIAC arbitrations under the new Indian regime. We've got a very strong panel with us. I'm going to keep introductions short. Gary, of course, needs no introduction. You've heard from Gary. Next to Gary, we have Elodie Dulac. Elodie is a partner with King & Spalding. And next to Elodie is Manish Lamba, who's General Counsel at Bharti Realty Limited. On my left here is Kim Beng, a partner of Raja and Tan and an old colleague. Mr. Ravi Shankar is next to him from Law Senate, and Kabir Singh from Clifford Chansom. And all their biographies are in the program, so you can look them up. But they're all extremely well known and great experts in arbitration, so we'll have a good session discussing quite a few issues. So what we're going to do is we have quite a few issues that we need to cover. And we're going to walk through the arbitral process, in a sense. and discuss certain topics from the arbitral process that would add to successfully managing SIAC arbitrations under the new Indian regime. We're going to start with steps and strategies to be considered before commencing an arbitration. And then we'll look at the appointment of an arbitrator, specifically with from the point of view of the new regime of the Indian Arbitration Act, which incorporates the IBA rules on conflict as a statutory regime. And then we'll look at some of the specific processes under the SIAC rules that would help to add to the successful management of SIAC arbitration. We're going to look at consolidation and joinder. We'll talk at the emergency arbitrator. We'll look at expedited procedure. And we're going to end with early dismissal. So we're walking through an arbitral process in a sense. How we're going to do this is each of the 6 speakers here are going to briefly introduce one of these topics, and then we're going to have a panel discussion on each topic, and then we'll move on to the next one. We'd like to make this as interactive as possible. And we've got quite a tight time frame because we've got 90 minutes to do 6 topics, so it's not that much time to do each topic. So in order to make it as interactive as possible and to keep things moving, I'll invite the audience, if at any point of time on any topic you want to raise a comment, ask a question, do put your hand up and we'll try and incorporate that as well. But let me then start with the first topic, which is steps and strategies to be considered before commencing an arbitration. And Manish will introduce this to us. And of course, with a very interesting perspective, because Manish is actually a user and will tell us what he does to prepare for his arbitrations.
Good afternoon. We had a very interesting introduction today. I think 2 things which resonate, which I heard from the introduction, is one is Mahabharata and the second is food. So both give us food for thought. The actual war at Mahabharata took place for 18 days. And Mahabharata is divided into 18 adhyayas. So if you parvas, and if you look at the manner in which, as it said that the conciliation efforts were made by none other than Lord Krishna, before the final battle was fought, and the story goes after 36 years. So what do we do in order to, when we have to begin from the beginning, that what is the strategy? And today we have the new rules, the Siac rules, or the Indian Arbitration and Conciliation Act. As an in-house counsel, what am I supposed to or required to do? Looking at the fact that we are the, if it were simply Gary gave that of a TV serial, and if I were to give up a film, I would like to believe that we are the producers of the arbitration. If not anything else, we would also like to see that if we could be partial directors, producers and partial directors of the arbitration which takes place. So first things first, insofar as the strategy is concerned, that what we need to take into account insofar as counsels are concerned, it's very easy to complain about time and costs. But a lot of time and cost is within our hands when we draft contracts. So we need to ensure that we draft these contracts in a manner that they leave very little to dispute. They are drafted in a manner that they take into cognizance not only the act, the substantive law, but they also take into account the procedural aspect of an institutional arbitration, if that were you were to choose. And yes, we need to see, insofar as the agreements are concerned, they are drafted in a manner that not only a person reading it bona fidely interprets in a manner in which it ought to be, but also a person who reads it in a with a non-bona fide, in an unbona fide manner, that he is not able to misinterpret it, but we are not able to reach that precision, as a consequence of which disputes do arise. We need to ensure that the arbitration clause is drafted properly. It is not only a midnight clause. We need to be very cautious that we are conscious about the seat, the venue, the language of arbitration and the substantive law. Seat and venue are not to be confused with the new arbitration rules. We need to be even more cautious although the choice has been given. So we must exercise, and if nothing else, we must bodily lift the arbitration clauses of institutional arbitration, which will make life simpler. As in-house counsel, what is expected from us is that we need to be master of the facts. If we are master of the facts, we need to control them. We need to provide all the assistance. We need to have a cost-benefit analysis, appraise our management with respect to the cost and consequence of if we were to arbitrate, should we or should we not mitigate our risks, what kind of a correspondence, what kind of evidence, what kind of documents. So we need to have to put our house in order, to facilitate, to choose a very correct law firm, the correct for the kind of dispute, choosing of the arbitrators, these is also within our hands. So if the framework what we as in-house counsels can provide, that would help, and we need to work as partners with law firms and lawyers, and fully exploit the provisions of the rules and the laws in a fair manner. There are fantastic provisions with respect to emergency. We need to provide the facts and circumstances. We need to see whether what are the parties which are required to be joined, or what are the disputes which can be joined together. And in a way, we need to synchronize with the law firms, the lawyers, and the institutions in order to come up with a desired result. I think that's a short introduction.
Thank you very much, Manish, for that. You called the role of the in-house counsel, general counsel, as a producer of arbitration, which is a very interesting concept. Which would you say would be the most critical aspect that the in-house counsel has to face when considering whether to commence an arbitration? What is the most critical aspect, do you think, the most important decision that you will make as an in-house counsel?
See, I need to have a prima facie view. What is expected to me is to have a complete control over the facts, the issues, the disputes, and what is the likely consequences of it. So once I know in the realm of realism, I need to weigh all my options, need to understand if I were the arbitrator, then what is likely to be the consequences, and I need to do a sensitivity analysis. If things go absolutely right, what would happen, and if they were to go, if the pendulum was to swing the other way around, what would happen? And somewhere down the line, I need to give a informed judgment to the management to deal with, to settle, to proceed, whether it is in the benefit of the company to settle or to arbitrate. So these are things which I need to take a call, and sometimes not unnecessarily arbitrate or litigate on a matter which I am quite confident or sure would go which way.
Thank you, Manish. Let's try and look at this from a different perspective, which would be from the perspective of counsel, having experience worked with representing parties in arbitration. What do you think as counsel would be the one or two critical things that should have been done prior to commencing the arbitration that might have made a difference? Maybe we can take a few. I see people reaching out. Elodie, you seem to be jumping up for that.
One thing that comes to mind, and which is rarely done and sometimes resisted by clients, is if you are asking for monetary damages, which usually you are, assess the chances of actually, if you get a favorable award, enforcing that award and getting that money. And sometimes that means tracing the assets. And I think clients rarely take this initiative before the arbitration of tracing the assets if they are not sure which company holds actually the assets, which may have been moved around, and usually are not keen when lawyers start suggesting like incurring these fees for something which is for the post-award phase, for the enforcement phase. But ultimately, if you think about the end game, that's something which should be done more often.
Thank you, Elodie. Anybody else in the panel want to? Gary?
Just a couple thoughts from the perspective of counsel, and polling in slightly different directions. One, it's always critical and sometimes not so easy with clients to understand the full factual record. There sometimes will be, for cost consideration or other reasons, a hesitance to invest very much at the outset of the case. But in fact, when you're about to begin an arbitration, you're starting something that you may ultimately not be able to stop. And it's therefore, I think, essential that you really understand what the facts are. And in an era where everything is on the internet or emails, it's usually easier to do that, but also more important to do it because the likelihood that at some point it comes out is fairly substantial. And so I think investment up front in really understanding your case, its strengths and weaknesses is essential. Pulling slightly in the other direction, I also think it's always essential to explore with the other side or sides settlement, including through conciliation or mediation. One of the things that at SIAC we do in our initial letter after the request for arbitration has been filed and is being conveyed to the respondent or respondents is to point out the availability of mediation services under the SIMC, the Singapore International Mediation Center. And I think many times parties are a little hesitant to talk to the other side. They think it shows weakness or something of that ilk. I think, in fact, though, it gives you more information, which goes back to my first point that at this stage, the more information you have, the better.
Thank you, Gary. Maybe at this stage, I'll give an opportunity. It'd be interesting to hear views from other in-house counsel. Is there anyone in the in-house counsel in the audience would like to share one or two comments about what would be the most critical aspect in making a decision prior to commencing an arbitration? No takers, right? Let's move on next to the next stage of the arbitral process. You decided to commence arbitration. Now you've got to appoint your arbitrator. And Kabir is going to address us on the particular aspect of that, of the importance of choosing the right arbitrator, especially under the new regime in the India with the IDA rules and conflicts getting statutory acceptance under the Indian Arbitration Act.
Thank you, Stephen. Now, what I'll do over the next 2 or 3 minutes is to cover this topic first at the level of generality of what are some of the fundamental issues that one confronts when appointing an arbitrator, and then to look at it in the specific Indian context. Now, I think the right to choose an arbitrator is probably one of the most fundamental advantages or perceived advantages that international arbitration offers, and I think those of us that brandish it as the more attractive method of dispute resolution will always say that this is one of the fundamental advantages. And again, every client that I've spoken to has always taken the view that the choice of an arbitrator is perhaps the most important decision that's going to be made in the arbitral process because it could effectively make or break the arbitration. Now, nevertheless, I think the concept of party-appointed arbitrators obviously has been, middled with some amount of controversy. You've got academics and arbitration professionals on one end of the spectrum who say that that's a very dangerous process, and that process perhaps has outlived its use. We should turn over everything to the institutions. But on the other hand, and again, just to share the results of a survey that was done in 2012 by Queen Mary University in White Case, where users were asked, by what method do you favor selection of 2 co-arbitrators in a 3-member arbitral tribunal? Now, a majority of 76% said that they preferred unilateral appointment of the 2 co-arbitrators by the parties, and of the user groups, private practitioners, had 83%, and they favored that the most, followed by in-house counsel at 71%, and surprisingly only 66% by the arbitrators. So, the preference clearly is for parties to continue to be able to have that right to appoint the arbitrators. But I think with that comes the tension of you need to appoint an arbitrator, but that arbitrator needs to remain independent and impartial. And how do you do that? So Professor Martin Hunter, and again, I know he's been quoted a lot on this, but this probably puts it the best way. He says that where I'm representing a client in an arbitration what I'm really looking for in a party-nominated arbitrator is someone with the maximum predisposition towards my client, but with a minimum appearance of a bias. And these are sort of telling words, because I think that probably shows, you know, what goes on at the back of counsel and, again, the client's mind when appointing an arbitrator. Now, again, that decision is not an easy one. You know, one has to look at a whole, you know, range of factors when determining whether that particular individual is suited. Does he have the right qualifications? Whether there are qualifications in a particular area of law or technical expertise, if it's a complex technical dispute, whether that individual is even available. And again, sometimes the issue with many big name arbitrators is they're very good, but they're also very busy. And do you want someone like that? The issue of nationality and cultural affiliation. Would that particular party prefer an arbitrator of his nationality, or can he do with someone else? What about personalities? Again, the arbitral tribunal at the end of the day is a human tribunal. It's made up of humans with different personalities. And if you're appointing, you know, one of the party-appointed arbitrators, do you have that person who's going to be convincing, or someone who with the intellectual rigor to go through that process? And again, you see a lot more time being invested in the selection process, such that parties are now even indulging in arbitrator interviews at the pre-arbitration nomination stage, where they effectively engage with their potential nominees to find out, you know, about their background, about their availability. So it's a very important process. Now, sort of bringing that down to the Indian context, when the Act was amended and when the amendments were passed in 2015, I think the two real areas of concern that the amendments were seeking to sort of address in this issue was the issue of disclosures of potential conflicts of interest. So issues like repeat appointments, you know, undisclosed affiliation to parties, which was felt to be, you know, a pervasive problem in the Indian context. And the second kind of sort of fact pattern that was going to be addressed was the issue of arbitrators being directly linked in a manner that's known to the parties. And again, those of you familiar with the government contracts, you will know that it was very common in India, and still is to some extent, that arbitrators are chosen on the basis that they're actually employees of the government or consultants to the government. So they're actually overtly linked to a particular party. And again, that was sort of seen as unacceptable. And again, the way the Law Commission sort of responded by that was to, in a sense, incorporate substantively, you know, the circumstances set out in the IBA rules on conflict of interest, and those have now made their way into the 5th and the 7th schedule of the Act. Now, one point, at least on my radar, which is, I think, worth talking about a bit more, is the new section 12.5. And that section is interesting in my view because it effectively, in a sense, overrides the party's agreement of an arbitrator if that particular arbitrator has a relationship that falls within one of the sections or one of the circumstances described in the 7th schedule. So it's an interesting evolution. Again, I don't know of any other major arbitral legislation that's gone that far. And some critics have obviously said that, you know, people went too far to the other end of the spectrum. But I think it's probably, you know, something that was responsive to the problem. And, you know, perhaps they may not have got it perfectly right, but it was important to get India in the right direction. So just very quickly, what are some of the issues that it raises? Obviously, we need to consider the issue of conflicts, you know, even more importantly, because it's now sort of embedded as hard law under the Indian Arbitration Act for interseated arbitrations, both at the level of counsel and those of us practicing as arbitrators because of the enhanced disclosure requirements. Looking at 12.5 circumstances at the time of drafting your agreements as well, to say when you draft an agreement, are you drafting an agreement that's potentially going to violate 12.5 and therefore actually not be enforceable, because then you'd have to, you know, agree on the arbitrator from the outset again. So I think these are some of the issues, Stephen, that I would highlight as being topical.
Thank you very much, Kabir. So you touched on an interesting aspect of this, which is the making of soft law, so to speak, which is the IBA guidelines, which doesn't have any legislative effect, but more persuasive effect, into hard law, which is now statutory. The IBA rules worked within a certain framework. There were general standards that set out principles that should be applied, and then you had the application list, which is really what you find in Schedule 5 and Schedule 7, or some of the examples have come from there, have come from the application list. Do you see any issue, Kabir, with how, with the adoption of these application lists without taking them out of the context of the IBA rules, taking out of the context of the general standards, and also bearing in mind that the application lists were not meant to be exhaustive, as it says in the IBA rules, but more examples of situations? Do you see any difficulty in that approach?
Well, I think yes and no. I think yes, for all the reasons you mentioned, which is, those circumstances will sort of come about as being, the general broad consensus of the international community. And even then, the IBA rules, does have its critics. But I think one has to look at it in the context of the problem that India was facing at that point of time and the alternatives available. And I think given that the Law Commission recognized the issue of conflicts of interest as a serious and pervasive one, perhaps the only other option for sort of laying down these circumstances would be through the Indian courts. And, all of us familiar with India would know that that can be a very trying, complex, and convoluted process. And so I think, it may not have been the perfect solution, but it's probably the best solution they had, at the time.
Thank you. You raised some other interesting comments about the appointment of arbitrators. And one you made about how when choosing a party-appointed arbitrator, you look for maximal disposition towards your case, but the minimal appearance of bias, which could be quite a contentious statement. But let me ask the in-house counsel here on our panel, what do you look for when you're appointing an arbitrator? Do you leave it to your counsel? Do you just let your counsel advise you on who you should appoint, or do you have specific thoughts and criteria of your own?
This, at our end, happens with a consultative process. We do not have any strict guidelines or the manner in which we look at it. We look at the nature of the dispute. We have a consultation with the lawyers or the law firm. We need to be very correct in choosing them. And we need to get advice, and we, depending upon the facts, we would like to have as many data points as possible before we come to a conclusion. And at the same time, we are on the right side of the law, and we ensure that there are no biases and there is nothing in law which prevents that person from acting on our behalf. But we certainly look at the stature of the person, the credibility of that person. We do not interview them, but a lot of information is available in the public domain and with most of the law firms that we do engage. That's how we do it.
Thank you very much, Manish. Well, staying with this perhaps controversial statement that one is looking for an arbitrator with maximal disposition and minimal appearance of bias, I would like to ask some of the other panelists, what are your thoughts on that? Is that what you're looking for in an arbitrator? Is that what a party-appointed arbitrator should be? Gary?
It strikes me as a rather superficial catchphrase. It's a little bit like winter is coming. It sounds good, but if you look at it carefully, it falls apart. The reality is you look, and I think Chris prefigured this observation briefly. When you look at the reasons that you choose an arbitrator, those two considerations, maximum bias, minimum appearance of bias, are really far down on the list, if at all. You look at the qualifications in the case. You look at language. You look at the applicable law. You look at the industry sector. Is it insurance? Is it construction? Is it joint venture? You look at availability and also past track record. In that regard, I'd like to put in a small commercial plug for a resource that some, but perhaps not all of you have heard of, Arbitrator Intelligence, founded by Catherine Rogers, who's quite active in the field. It will provide online summaries of users' past experience with arbitrators. I think it's a hugely useful resource for both law firms, but also in-house counsel. I think the kinds of considerations that one sees from that, how arbitrators have actually handled cases in the past, is much, much more important than this sort of facile, I want somebody who's predisposed towards me, but won't look that way. I think that sounds good, but when you actually think about how cases actually are handled, it is not very realistic.
Very much. Kim Beng.
Just to just to add to what Gary has said, what we tend to do when it comes to assisting clients in appointing appointed arbitrators is that, well, to discern the maximal disposition, it actually helps to do some research to gather intelligence on the track record of the arbitrator, particularly on his inclination on certain issues. So we would be looking at cases where they've been involved in, or even academic writings to see where their leanings are towards. So that's part of what we do to get a sense of the disposition. Perhaps not quite to the extent of getting a fix on the maximal disposition.
Well, you raised an interesting point there, which I'd like to ask you. Has that actually led to any success? Can you tie that research or work that you did to the final result and say, well, yes, we anticipated this?
To be brutally honest, no. It helps the selection process in a sense that when we array the candidates before the clients, it helps the debate and the selection process to discuss with the clients where these arbitrators have gone before on similar issues. But of course, there's never any guarantee that they're going to end up in a similar, with the same decision on that issue in this particular case. And it's hard to find a correlation.
Well, I'm just looking. Any last comments before we move on to the next? Okay. Let's then move on, actually. And then we're going to talk now about consolidation and joiner. This will be an introduction of the new SIC rules introduced in the 2016 rules on consolidation and joiner. And Kim Beng is going to introduce the topic for us.
Thanks, Steve. Of the different features that were introduced by the SIC rules in 2016 to facilitate and enhance the arbitration experience for users of the arbitral rules of the SIAC, I think the provisions on joiner and consolidation are probably one of the more controversial ones. It's a subject that's close to my heart for a couple of reasons. One, because I'm involved in a couple of applications pursuant to those rules. The other reason why it's a subject that's close to my heart is because I was involved with the Academy of Law in one of the subcommittees that looked into whether we should be making a push to introduce provisions for joiner and consolidation in arbitral rules. We were overtaken by the institution because it was introduced in 2016, but for some of you may know that SIAC adopted those rules a little bit later compared to other arbitral institutes. The reason why it's controversial is because it's probably one of those features that cuts closest to the cornerstone of the arbitral process, which is party autonomy. And taking the consolidation provisions, for example, what you have is a set of criteria that the applicant has to satisfy before the applicant can make the application for consolidation. Now, of the set of criteria, 2 of them have to do with the arbitral agreements either being identical or similar, and with further sub-criteria having to do with the issues, having to do with commonality of issues and facts. So the point here is that as a compromise, or perhaps not a compromise, but the requirement in order to allow a consolidation to happen is that there has to be that similarity or that closeness in the identification of the arbitration agreement. Now, the exception is that if the parties come to an agreement consenting to the consolidation process. So that's the first criteria that has to be satisfied. But even if the criteria is satisfied, it doesn't automatically guarantee that consolidation will take place, because the application, if it's made to the SIAC, would then be considered by the SIAC court, and the SIAC court would be exercising its discretion on whether to grant the consolidation application. In coming to its decision, there will be an opportunity given to the parties to provide their views, and this would be done in writing. And after the parties provide their views, the SIAC court would be taking that into consideration, as well as having regard to the totality of the circumstances of the case to decide whether to grant the application. So as you can see, it's not a straightforward process. It is a process that ultimately hinges on what the court sees as whether this is a matter that's fit for a consolidation. Now, if the court grants the consolidation, an important point to note is that it is without prejudice to the party's ability to challenge the jurisdiction of the tribunal that's eventually constituted. and the tribunal has the power to decide that question as well. The other thing that happens if the SIC court grants or declines the application is that it is without prejudice to a party refreshing the application to the tribunal once it is constituted. And the difference here is quite important because essentially an applicant has 2 bites of the cherry for consolidation. You do it once before the SIC court. If you're not successful, you can do it again once the tribunal is constituted. In terms of the criteria to be satisfied, they are similar. However, the one key difference is that where the application is made before the tribunal, if the second tribunal has already been constituted in the subsequent arbitration, and that tribunal is not the same as your first tribunal, then the opportunity to make the application is no longer available. So timing is critical if the intention is to bring an application for consolidation before a tribunal once it is constituted. Now, if the other point to note about consolidation, and again, this is yet another reason why perhaps it's one of the more controversial provisions, is that once an application for consolidation is granted, then if no tribunal has been constituted at that point, Rules 9 to 12 of the SIC rules will apply in the appointment of the arbitrator and the constitution of the tribunal. And that has raised objections before, in the sense that parties have protested that this is actually undermining party autonomy when it comes to exercising their right to nominate the arbitrator or to participate in the process of the constitution of the tribunal.
Thanks, Kim Beng. Well, you touched on a very interesting aspect of the way the SIC deals with joint on consolidation, which would be the impact on the party being joined or the parties being consolidated into the arbitration on the process of appointing the tribunal. Now, under Rule 7.6 on joinder and Rule 8.6 on consolidation, the court may revoke the appointment of any arbitrators appointed prior to joinder. If the court does not revoke such appointments, then any party who has not nominated an arbitrator or otherwise participated in the constitution of the tribunal shall be deemed to have waived its right to nominate an arbitrator or otherwise participate in the constitution of the tribunal. So, looking at these provisions together, it seems to me the court has a choice. It can either give a party being joined or parties being consolidated the opportunity to participate in the constitution by revoking the appointment of any arbitrators appointed, or it can effectively bind that party to the tribunal already constituted. Now, I can understand that perhaps in particular situations, in cases, there would be one reason why the court might choose one rather than the other, but all things being equal, which route should the court take? I'm going to ask you this question first, but I'm of course conscious we've got the precedent of the court here, so I'm trying to ask you this question as well. But from the perspective of counsel to a party, which route do you think? Do you think the court should exercise the discretion to revoke the appointment of any arbitrators and tend towards giving all the parties then who are joined or consolidated into this arbitration the opportunity to participate in the process, or do you think it's fine if the party being joined or consolidated is bound to accept the arbitrators that have already been appointed?
My sense is that the court, now there is a provision in the SIC rules that says that arbitral appointments should be made as soon as practicable. And I think that the point about being practicable takes into consideration the process that has to play itself out in an application for consolidation. So you've brought up an interesting point in terms of when the SIC court is going to exercise a decision to revoke an earlier appointment. But from the experience that we've had, our sense is that the court would have pause to make the appointment so soon until it has played out the consolidation process and determined the application. So what I mean is, where the application for consolidation is made to the SIAC court, that means that the tribunal has not yet been constituted. Now, there may be an appointment or two that has already been made, but the point is that the constitution of the tribunal has not yet taken place. If the SIC court grants the application for consolidation, then it's actually Rules 9 to 12 that apply and would override the arbitral appointment process. So, for example, if there are more than, after the application is granted and there's consolidation of proceedings, and you have more than 2 parties to the arbitration, then you would have Rule 12 applying, where the claimants and the respondents would be required to make joint nominations. And if they are unable to make the joint nominations, then the SIC court, the president of the SIC court, would be making the appointments.
Well, thank you, Kim Beng. That's the council's perspective. I'm dying to ask this question, so I have to ask this question. My one opportunity to put it to Gary. What's the court's view on this?
Actually, my door is always open. If any of you have questions, never hesitate to ask. So you have multiple opportunities. I think the general approach of SIAC, without talking about specific cases, is wherever possible to respect party autonomy and also the rights of all parties to participate in selection of the arbitral tribunal. I think the general approach, again, without talking about specific cases, would be to not bind parties with choices in which they had not, but others had an opportunity to participate. We do face occasionally instances of at least asserted conflicts between arbitration agreements and the SIAC rules, questions as to which provision, a provision in the SIAC rules or the arbitration agreement about selection or number of arbitrators prevails, and it's an issue that both we and national courts are, I think, still exploring.
Thank you, Gary. I'd like to focus on another aspect of the joinder and consolidation rules, which are this concept of determining whether a party, focusing specifically on joinder, that whether a party is prima facie bound by the arbitration agreement. Under Rule 7.1, which is joinder by a court, or under Rule 7.8, which is joinder by a tribunal, and I think the question applies both to joinder by the court and by the tribunal. A party may be joined if he's prima facie bound by the arbitration agreement. So what either the court or tribunal is looking at, one of the criteria, is he prima facie bound? And the question I have would be whether you think there is a difference in how the court and the tribunal would approach this concept of prima facie. Is the court likely to adopt a lower standard or require less convincing than a tribunal? And to put this in context, under Rule 7.10, the tribunal's decision on a prima facie basis is without prejudice to its power to subsequently decide any question as to its jurisdiction. So even if the tribunal decides that a party is bound prima facie, that party presumably is still entitled to raise challenges to jurisdiction. But in that context, would a tribunal take a more stringent approach to this prima facie determination, since it realizes that if they make this determination, there's the possibility of them being in effect challenged, and they'll have to hear this again. So is there a possibility when you're faced with the option perhaps of making this application to the court or making this application to the tribunal, that perhaps there's a bit of a gaming of the system here, that you may get a better hearing from the court if you want jointers than a tribunal? Does anyone want to take this up? Elodie?
I suppose that I'm obliged to answer again in my role as president of the court. Again, as a general principle, I think inevitably the institution, the court, is more deferential, if I can put it that way, towards the arbitral tribunal's ultimate authority to determine jurisdiction, and hence I think there's probably a somewhat broader notion of what would satisfy the prima facie jurisdiction standard. I don't think we're unusual. SIAC is unusual in that respect. I think most institutions would regard their assessment of prima facie jurisdiction as one where the arbitral tribunal's ultimate authority to decide jurisdictional issues ought to be given maximal respect.
One final point about the consolidation provisions would be one of the criteria of consolidation is that the arbitration agreements being consolidated are compatible, but there doesn't seem to be any definition of what compatible is in the rules. So what is a compatible arbitration agreement? Kim?
I'll just share some thoughts on this. It's been said, and commentators have written up on this. Generally, when we talk about compatibility of arbitration agreements, we are looking at the features having the agreements having common features such as adopting the same rules, the same number of arbitrators, the same seat of the arbitration, for example. So it would be features such as this within the arbitration agreement that would be looked upon and compared to determine their compatibility.
Any more comments on this topic before we move on? Right. Then let's move on to the next topic that we're going to discuss, which is the emergency arbitrator. And Ravi will introduce this topic for us.
Okay, good evening, friends. Prior to 2010, one of the major challenges faced by the arbitrating community of the world was how to protect the party's interest, which is in real trouble, before the formation of the tribunal. The issue was very critical because parties are from different countries, assets are in different countries. So once you decide to initiate the arbitration process, maybe some of your rights, some of your properties, or some of the financial transactions may be in trouble. So to make an interim arrangement, what was the mechanism available at that point of time was to go to the other party's national court to get an interim protection by way of an interim order if it is available in that country's procedural law. That was the only option available at that point of time, which was very complex because every one of us know that parties wanted to get out of the national court system and come to a common system because of the complexity of the national court procedures in different countries. At this point of time, when SIAC brought in 2010, I was in a conference in Kuala Lumpur. There was a very, very critical comment by one of the leading arbitrators from Singapore itself. Later, I came to know he was appointed in a couple of emergency arbitration appointments itself, because the understanding was less. At that point of time, it was seen as a foreign body to an arbitration process, which was seen as something which is not fitting into the party's interests or party's wish. But actually what is happening is, if a party has a threat or an emergency and requires a relief before the formation of the tribunal, it has to seek the assistance of the SIAC by providing the information, all the necessary information, why they deserve a particular interim relief and what are the supporting documents and pleadings. Then President Gary will look into it and he has to take a decision whether an emergency arbitrator can be appointed. Okay, emergency arbitrator is appointed. Does he going to decide everything ex parte? It is also not there. He will also hear the parties, but within a very short time. Many awards have come out within 2 days, 3 days, to a maximum of 14 days, because the life of an arbitrator, emergency arbitrator, is 14 days. He requires to pass an award within 14 days from the date of formation of that emergency arbitrator. So within the short time, he is able to hear both the parties and give an award. Why we can go to the national courts, but keep one thing in mind: the beauty of the international arbitration system is the support what we get from the New York Convention. So the New York Convention will come to our rescue only when there is an award. It cannot come for a court judgment or a mediation proposal or whatever it is. It helps only the International Arbitration Award. So the Emergency Arbitration Award is treated as an International Arbitration Award. So it gets the support of the New York Convention to get it enforced. Okay, globally what is happening? Globally, if you see many countries like Hong Kong or Singapore, and all have come out with specific provisions recognizing the emergency arbitration award as a recognized type of award, which is enforceable. Unfortunately, in India, we tried, our law commission also tried, but we could not get given an official tag to that. So we have certain difficulties in enforcing it. Many of you know that we don't have a provision to enforce an international interim or partial award. There is a difficulty in that, because the Untitled Model Law Provision 17H does not reflect in our Act, even in the new Act. So there is a difficulty in enforcing. Even in the latest case, the Raffles case, the Delhi High Court has said an emergency award can be enforced only by way of filing a suit in India, which will be disastrous. But the reality is like this. Even though we have a difficulty in enforcing it in India, but it is all the GCs and the lawyers should understand that it is a wonderful provision internationally to have an emergency arbitrator to get an emergency relief for two reasons. One, many of the countries recognize emergency arbitration provision and the enforceability of the award. Number two, 70% of the emergency arbitrator awards are obeyed by the parties without even enforcement. So it is very, very effective in terms of a practical situation. None of the parties would like to go and challenge the emergency arbitrator award, because it will create a very bad impression in the minds of the incoming tribunal as well. You should also understand the emergency arbitrator goes immediately after his work is over. Mostly, unless otherwise both the parties agree, they don't become a part of the regular arbitral tribunal. But the regular arbitral tribunal has every right to relink it into the emergency arbitrator award and also make changes if necessary. So I think this is sufficient.
Right, thank you very much, Ravi. Well, you touched on this issue of the lack of enforceability of emergency arbitrator awards and decisions enforceable, either awards or decisions, and the lack of enforceability in India. But yet you recommend this. I take it from your introduction that you recommend this to Indian parties. Is this primarily on the basis the empirical evidence shows that there is a high degree of party compliance, or
even though there is no clear finding whether an emergency arbitrator award is also an arbitrator award, that is the one question which is going on. In my opinion, where the arbitrator's power is sourced from, it is sourced from the arbitration agreement. Once the arbitration agreement adopts SIAC rules, then the entire SIAC rules is adopted into the arbitration agreement. Then how one kind of device or one kind of a mechanism which both the parties accepted cannot be an enforceable award. Let us keep the law right now away. A day will come when the court in India will also decide that it is enforceable. On the other side, why I am telling is, maybe for the foreign parties I will give a different advice. When you come to India, we are very bad in enforcement, but we are very good in giving interim awards, interim orders, interim protections. So the foreign parties, we always advise you come and take an interim protection from a local court. That too after the new amendment. We have two different phases. One prior to 6th September 2012, when the Bhatia came. Prior to that, all the Indian courts had the power to grant interim orders in support of or against the foreign-seated arbitrations, which was taken away by Bhatia. But after that, now the courts have got it back from 23rd October 2015. Now courts can give interim protection in favor of a foreign-seated arbitration as well. So we advise the foreign parties like that. But for the purpose of Indian parties, I will say this is the best possible way to protect their interim interest by way of an emergency.
Stephen, I have a comment. I think just on the issue about enforceability in India, and doing that by the way of interim relief. I think there actually has been a case already in India, I think now about 4 or 5 years ago, in the Bombay High Court. So what happened there was it was a arbitration in Singapore. They went for emergency relief. They got the emergency relief. They came to the Bombay High Court, and while you're right, it wasn't enforced as an award. What they managed to get the judge to do was pass an order in identical terms. So in a sense, slightly backdoor enforcement. But you got the Section 9 order in identical terms as the emergency arbitrators award. So it actually has been done already in Bombay. And I suppose the question is whether other courts in India would be sort of open to this kind of solution.
Just to supplement my friends, all the important cases, 3 cases, have dealt with in the same way. They never went beyond the terms or the order of the emergency arbitrator. Both Bombay High Court and Delhi High Court entertained an application under Section 9 to give a similar interim order in the lines of a emergency arbitrator award. So the courts are very much keen in supporting the system. Even though they are not able to directly enforce, they are giving effect to the emergency arbitrator award by way of a Section 9 proceeding.
Well, that discussion, I think, raises an interesting question about the choice, because ultimately the emergency arbitrator provision gives you a choice in most cases of choosing to either go to the emergency arbitrator or you could still go to court. It doesn't take away the party's right to go to court. But in the Indian context, and Ravi, you commented that the Indian courts are known to be very effective in giving interim relief. So in that context, where you have an arbitration that involves an Indian party and the interim relief you want is against that Indian party in India, would you say it would make more sense then to come directly to India, get that award, that interim relief, or would you still recommend going to, say, a tribunal seated in Singapore for that interim relief?
See, in my opinion, that will be unnecessary 2 courses. Number 1, for the reason, one is, unless otherwise, if it is a very complex situation, maybe emergency arbitrator, after hearing both the parties, may give a longer, detailed, convincing reasons for the award, which may be of help in getting a local interim order. But otherwise, as I told you earlier, with regard to the parties, when an award is to be procured against an Indian party, the best route will be coming directly to the Indian courts if there is a real emergency of something happening, because within the few days of emergency arbitrators proceedings, maybe you will lose that cause of action by delaying that process. But if it is a complex order where you require a reasoned order to support your this thing, then definitely emergency arbitrator award will be of help in getting an effective, clear Section 9 order also.
Looking at the panel, see whether anyone's going to make a plug for the SIC, but saying you should go to the emergency arbitrator even for arbitration or arbitrations involving Indian parties.
Yeah, I think Stephen, the only other exception, I suppose, is when you want relief against third parties as well. And in that situation, perhaps you may not be as strong if you only had an emergency arbitrators award or order, for example, against a bank in India. So you may have tactical considerations on when you want to run straight to the Indian courts to short-circuit that process.
Thank you. Well, staying with this option of going to court or going to an emergency arbitrator, I mean, I've certainly taken the view before that I think there may be a difference between how a court would approach an application for interim relief and how an emergency arbitrator might approach that. And that could well result in a material difference in whether you get the interim relief or not. I'm interested in thoughts on the panel here, whether they have experience or similar thoughts on this. When you're making that choice, do you go to the emergency arbitrator or go into court? Perhaps broaden this out of the Indian context, but more generally. What considerations do you have? Do you automatically go to the emergency arbitrator because it's arbitration, or do you think sometimes it may make more sense for me to go to court, sometimes to go to the emergency arbitrator? Gary said.
Stephen, I think it's really hard to disagree with your final proposition. I think the judgment as to which forum you want in a particular case depends very much on the facts and circumstances of the case. There may be a situation where you actually think the local court won't be terribly hospitable or available or fast. There may be other circumstances where you have exactly those concerns about an emergency arbitrator. I think one that has to make as counsel a judgment based on the circumstances of each case. The availability of an emergency arbitrator, though, adds to the available options that you have to assess, and that can't be anything but a good thing.
Right, thank you, Gary. Let's then move on in the interest of time to the next topic, which is expedited procedure, and we're going to hear from President himself on this topic.
I hope I can remember all this. I try to put myself in the shoes of Manish because, in a sense, he's the most important person on the panel in the room, the user. And it was with Manish's concerns in mind, objectives in mind, that SIAC 7 years ago now adopted the expedited procedure as one of the first institutions to do so. In the ensuing 7 years, we've had 350 applications for expedited procedure, or what we call EP, of which we've granted roughly 200 of them. So not far from 50% of all EP cases, of all cases where EP is sought, we have granted expedited procedures. This is not a small percentage of SIAC cases. This is 20% or so of all SIAC cases over that time period. So what we're talking about is a serious proportion of our caseload directed at trying to meet users' objectives. What are those objectives? Those objectives are, in a sense, going back to the 5 E's that I talked about in my keynote. Most importantly, expedition and efficiency. If you have a relatively small value dispute, you don't want to wait 18 months, 24 months, whatever the number may be, either before or after the amendments to the Indian Arbitration Act here. You want that dispute, which is in a sense a sort of routine case handling dispute, handled very rapidly. And therefore, Rule 5 of the new SIAC rules provides that a party may, typically when filing their request for arbitration, request so-called expedited procedure. And the court has the authority to expedite the arbitration, even though ordinarily it would be handled in the usual course under the SIAC rules. In order to expedite an arbitration, a claimant typically must show any one of 3 things. First, that the dispute involves in aggregate. That means claims, counterclaims, all claims. The amount in dispute is less than 6 million Singaporean dollars, 5 million US dollars roughly. Or that it is a case involving exceptional urgency, or, again alternatively, that the parties agree that the case should be expedited. The court then has discretion, even if any one of those factors appears to be satisfied, to decide either to expedite or not to expedite the arbitration. If it decides to expedite the arbitration, then several things happen. First, the arbitral award must be made within 6 months. Second, the court, President of the Court of Arbitration, has the authority to order a sole arbitrator, as opposed to 3 arbitrators. And third, the arbitral award can be in summary form. All of that is designed to provide a very fast-track arbitration. We sometimes worried, to be honest with you, at Siac, whether it was too fast-track, whether this is what Manish and his other friends who are users actually wanted. So in our consultation process for the most recent rules revisions, we asked users extensively, is this what you want? And the answer overwhelmingly was yes. For small value disputes, this is precisely what we want. And we've had extremely good experience with both compliance and enforcement of the 20% or so of our cases that we have ended up expediting. I should note that we have some escape valves in the EP procedure. As you may recall, the court does not have to expedite even if one of these three factors, for example, a dispute of less than 6 million Singaporean dollars, is satisfied. The case may look complicated. There may be particular circumstances that make the court concerned that a party would be denied its opportunity to be heard if the arbitration were conducted in only 6 months. There may be other reasons. But the court does not have to expedite, even if the formal criteria are satisfied. Second, the registrar has authority in exceptional circumstances to unilaterally extend the 6-month deadline if during the course of the expedited arbitration it becomes apparent that that would be appropriate. And finally, the arbitral tribunal has similar discretion. It's not frequently used, it's virtually never used, but it is there as an escape valve if, although the case looked appropriate for expedition, it turns out in practice it wasn't so appropriate. Our experience thus far has been that users value this enormously, that the EP procedures, which we have a lot of experience in administering now, are a real attraction to business users around the world.
Thank you, Gary. Well, in your keynote address, Gary, you tantalized us with the possibility of a learned disposition on Rule 5.3 of the SIC rules and its intersection with the New York Convention. There was a recent case, I believe, where a Chinese court has refused enforcement of an expedited procedure award on the basis that the tribunal was not constituted in accordance with the parties' agreement. I think in that case, the agreement provided for 3 arbitrators, and 1 was appointed for the expedited procedure. So, Gary, I can't avoid asking this question: then, what do you think that provision in the expedited procedure rule still works? That you should still have the option to reduce 3 to 1?
Perhaps I should not have given that keynote. Perhaps I should have just talked about Rule 5.3. I can tell it has enduring interest in this room, at least. Rule 5.3 of the SIAC rules provides that if a case is expedited, it will be conducted in accordance with the SIAC expedited procedure rules, notwithstanding any contrary provision in the parties' arbitration agreement. What that means essentially is that in cases where parties have agreed on a 3-person tribunal in their arbitration agreement, if the arbitration is a small value dispute or of exceptional urgency and it is expedited, then it may be conducted before a sole arbitrator. I should underscore, in SIAC's view, this is not inconsistent with either the parties' agreement or party autonomy. The parties' agreement consists of 2 things: a general agreement on an arbitral tribunal of 3 arbitrators, and a specific agreement in small value cases on the possibility of a sole arbitrator for just that case. You don't change the parties' arbitration agreement. You simply, for a small value case, apply the expedited procedure rules, which provide for, at least potentially, a sole arbitrator. A case involving precisely these facts was considered by the Singaporean courts, who enforced an award made by a sole arbitrator where you had an arbitration agreement providing for a 3-person tribunal. An intermediate appellate court in China, in Shanghai, has reached, at least on unusual facts, a different conclusion. Has concluded that, in fact, the parties had agreed specifically on a 3-person tribunal, and that, if you will, overrode the expedited procedure provisions. I think, from my perspective, the Singaporean courts got it precisely right, that when parties sign up to the SIAC rules, they sign up to the possibility of a sole arbitrator. We will be considering issuing further guidance and clarification in order to make sure that parties are aware of that, and also clarifying the possibility of an opt-out. Parties can opt out of expedited procedures. They don't have to agree to that, or they could have a specific override with regard to the number of arbitrators in an expedited procedure. Fundamentally, what is at issue here is ensuring that party autonomy is respected, as I believe the Singaporean court did. I think parties know, especially sophisticated business users like Manish, know what they're doing when they agree to the SIAC rules, and the important thing is to give effect to those choices. And again, I think the Singaporean courts have done that quite well.
as it has been said by you, that it is not inconsistent. So once I adopt the rules, then I am bound by it, and the rules say so that if the disputes were of a small value, then what I have, if I may have stated that there would be one arbitrator appointed by both and third by the arbitrators, that gets substituted by the rule. So they have to be harmoniously read along with the agreement.
Exactly right. I couldn't say it better.
Thank you very much, Manager, for that ringing endorsement on behalf of the in-house community. Excuse me. Well, staying with this number of arbitrators in the expedited procedure, there is a possibility of the SIC court reducing the number of arbitrators from 3 to 1, should there originally have been 3 arbitrators. My understanding from statistics from the SIC is that most of the cases in which expedited procedure is granted involve that first criteria, which is that the value of the dispute is less than 6 million. It's always done on the basis that it's a smaller value dispute, and therefore you can save time and cost by going through the expedited procedure. And presumably as well, I think, I don't have all the figures, but empirically I think most of the expedited arbitrations are conducted by a sole arbitrator, not by 3, although there are a few instances where you have 3. And the question I have for Gary as President of the Court is what circumstances would justify appointing 3 in a situation where it's a low value dispute? And how does that, how does the need of appointing 3 outweigh the saving on cost of 1?
So I think I should stop being president and let either Stephen or Manish take over the responsibility, since they clearly have mastered the intricacies of the EP, at least as well as I have. Stephen has outlined precisely correctly the historic experience with expedited procedure, the fact that ordinarily it's a small value dispute, virtually never relying on the exceptional urgency alone, the fact that in most cases, virtually all cases, it's a sole arbitrator. And in general, when you think about it, in order for the expedited procedure to actually be expedited and to actually be cheaper, you need a sole arbitrator. You can shorten the arbitration somewhat if you have a 3-person tribunal, but we all know the difficulties in coordinating 3 busy diaries, 3 busy calendars of arbitrators. And we all know that if you have 3 arbitrators, it costs 3 times as much as if you have 1 arbitrator. And therefore, many of the benefits, perhaps not all, but many of the benefits of expedited procedure come with a sole arbitrator. And I therefore think preserving that possibility is fundamentally important. You can imagine cases, particularly, for example, if the parties have agreed on a particular kind of expedited procedure, perhaps in a larger value case, perhaps where they absolutely both want a decision in a particular time period and can cooperate together to getting there. You can imagine having a 3-person tribunal and still preserving the benefits, but I think those are unusual cases.
Thank you, Gary. I'd like to take the discussion on expedited procedure to an Indian context now, and ask a question about the Indian Arbitration Act, Section 29B, which provides a fast-track arbitration. So there's a possibility then of a process that's similar but almost not identical to expedited procedure in India under the fast-track procedure. So the question I have, perhaps if I can pose it to Ravi as our Indian expert here, is what if you had an arbitration seated, SIC arbitration seated in India? So the Indian Arbitration Act would apply as well. What would you advise your clients to do? Would you say go for the SIC expedited procedure or take the fast-track procedure under the Indian Arbitration Act?
See, now there are many parties. Indian parties are choosing SASC administered arbitration seated in India. That is becoming very popular these days. This is not only because of the time. The time provided in Section 29 is for an ad hoc arbitration, which is in which specifically parties have chosen to go for a fast-track arbitration. Then only this will apply. But SASC advantage is different. They give a different category. That means the sum of the project may be 1,000 million, but your claim is 2 million finally. You need not go for an elaborate arbitration procedure. You can just fit into the fast-track arbitration procedure. But in adopting this section 29, you will fall into a difficult category. That tomorrow you may require a larger time to be spent, and the issues involved between the parties or disputes arose out of the contract may be very complex in nature. So it is not, in my opinion, I will never advise, except financing contracts, I will never advise any party to adopt this fast track procedure provided in the Arbitration and Conciliation Act. But Siac procedure is much more safer, and that is the most efficient one for the purpose that if you require a fast track procedure, you can opt for it. Or if you fall into the default amount which is specified in the Siac rules, then you can automatically, you will be going into the fast track procedure. Otherwise, you will follow the regular procedure. So, in my opinion, I will say these Siac rules will be the best solution for an Indian seated arbitration as well.
Thank you very much, Ravi. Another ringing endorsement from India for the expedited procedure. Before we move on, let's just take a quick look. Anybody else want to raise any topics on expedited procedure? All right. Could you speak into the microphone? We can't hear you.
From Power Grid Corporation. I'm the legal head there, deputy legal manager. I'm looking northern part. What Mr. Ravi Sundaran said, in second part I will come to Mr. Bank. As far as Indian arbitration, my little understanding of the amendment in the Indian Arbitration Act. What Mr. Ravi Sundaran said, as far as emergency award is concerned, our law amended with provision are silent. Similarly, we have in Indian and domestic particularly, we have even in amended Act, we don't have a provision for consolidation of the arbitration. And particularly when we have a different set of arbitrator also, though identical parties. So even Act is silent upon the arbitration. We have faced those issues. I am working in a all over India organization where we have 9 to 10 similar parties are there, but arbitrators were there. But in one of my conference, we were facing a problem in the context of Indian law. One of my conference I was talking to Mr. Pranav. He guided me that SIA has a provision for consolidation. But their guiding factor, which has been a limitation, because there is a different set of arbitrators. But one thing is, it has come to the aid that SIC is having a provision for consolidation also, which we are silent or we are not silent. There is nothing kind of a thing which is there, which was there in Indian content. So we have taken, even recommended even in our public sector, even the ministry, to have a provision for, Act is already talking about the institutional arbitration, to adopt the, particularly SIAC, because they have got a wide range of, as you said, for emergency also and for consolidation also. And this point we have taken up even arbitration, even judges who were the arbitrators, they were not agreeing. They have given the judgment against us. We gone to the High Court and then through these rules and all, we quoted and all, and then we got the consolidation. So SIA's rules have come to the much more helpful and guiding factor, even after the amendment has come into the place in Indian context.
One more.
Thank you.
Thank you very much. Well, I saw 5 minutes flash. I'm going to ask Pranav, we're going to move on to early dismissal, which is, I think, a very interesting topic. So I'm going to ask Pranav for 10 minutes. Okay, thank you very much. And Elodie is going to introduce the early dismissal.
Thank you. So what is meant by early dismissal? It's a procedure through which the arbitral tribunal will decide early on in the arbitration to dismiss part of the case or the entire case through a procedure within a short time frame. And what's really like this procedure was introduced in the 2016 SAC rules. It's Rule 29, and the SAC has been at the cutting edge of commercial arbitration in that respect. It is the first arbitration institution handling commercial arbitration to introduce this early dismissal procedure. Since then, only one other arbitration handling commercial arbitration has introduced something similar, which is the Arbitration Institute of the Stockholm Chamber of Commerce. There is one precedent of that procedure existing, which is in the 2006 rules of the International Center for the Settlement of Investment Disputes, ICSID, but that specific ICSID only deals with disputes between foreign investors and states. So as we mentioned, the expedited procedure, the emergency arbitrator, this is one of the tools the SAC, new tool the SAC has brought to the users, and it is there. It's not for every case by far. I'm going to come to the requirements for that procedure, but it's definitely to be noticed in the 2016 SAC rules. So coming to the grounds on which a party may request an early dismissal of a claim or defense based on this Rule 29, there are two grounds, alternative grounds. One is either the claim or the defense is manifestly without legal merit, and the second ground, alternative, is if the claim or defense is manifestly outside the jurisdiction of the tribunal. So I insist on the word manifestly. It's a very high threshold, and in the ICSID context, which has a similar procedure, it has been used with great restraint because the parties are aware that threshold is so high. In ICSID, there has been about 10 cases for early dismissal in 11 years. So when I say it's not for every case, it's parties have to be mindful. It's there, but it's a difficult threshold to meet. In terms of procedure, so a party willing to apply for early dismissal will file an application with the tribunal. There is no time limit in the Rule 29 for that application to be filed. However, the tribunal has discretion whether to allow or not that application to proceed. And one may think, like in the SAC rule, there is a deadline for jurisdictional objections, the real ones, which is that they have to be raised at the latest in the statement of defense. So one may think that the idea is not that an early dismissal will be filed later than that, and that's a circumstance in which a tribunal may refuse to let the application proceed. If the tribunal allows the application to proceed, then the other side, of course, is given an opportunity to respond, and then the tribunal will decide. The tribunal has 60 days, so short time period, to decide from the filing of the application. If the tribunal decides to dismiss the whole case, of course, at the end of the arbitration, it's an award. The tribunal may decide to not to dismiss any part of the case or dismiss part of the case, and the arbitration will continue. So one point, especially on jurisdictional objections, these provisions means that a party objecting to jurisdictions could have potentially three shots. It will have the prima facie screening by the SAC. Then it would have this early dismissal procedure, and if that fails, the party can still lodge a jurisdictional objection under Rule 28. So that's an overview of this procedure, which is a very interesting one, and we've heard earlier that the SIC has seen for the past year some early dismissal application, and I would be very interested to hear about this.
Thank you very much, Ellen. Well, taking up on one of the last points you made about this 3 shots at getting...
You're asking me about prima facie?
I'm going to ask you about prima facie, exactly. So, if you take the first shot, which is challenging jurisdiction before the court, when deciding that issue, must decide if it is prima facie satisfied that arbitration should proceed. That under Rule 29, the test before the tribunal is manifestly without legal merit. Do you see any difference in how these 2 thresholds are going to be applied?
I mean, on the 2 terms, probably not. Looking at the ICSID practice, where there is also, actually the ICSID screening by the institution is manifest, the word is the same. And I think what you see is that the control by the screening by the institutions is minimal, and that the control by the tribunal, even if the words are the same, manifest or prima facie, will be more, not in depth, but will go further. So I think, and definitely it's not because you pass prima facie or manifest screening by the institution that your early dismissal application is bound to fail.
I would jump into this. Maybe not dying to jump in, but happy to agree. One can look at both ICSID awards, which consider almost precisely the same argument. The request was registered by ICSID, therefore there must not be a manifest lack of jurisdiction. And tribunals, I think, have not been persuaded by that argument. There's a difference between the institution's decision and the arbitral tribunal's decision. I also think by the time you get to the arbitral tribunal, you often have evidence and certainly oral argument and other submissions that both can and should make a difference in the standard that is applied.
Thank you, Gary. I think the expedited, actually this is the one, unfortunately, we're dealing with it at the end, but I thought this is the most interesting development in the 2016 rules, because we are, to some extent, I think, in uncharted territory. You have the ICSID example, but I think the application of the early dismissal in the ICSID procedure is different from the way that SIC has adopted it. In ICSID procedure, you only have it for dismissal of claims, and you have to bring it before the tribunal holds first meeting, which means that at that stage, you only have to request for arbitration. You don't even have an answer. There's very little before a tribunal to make that decision, and I can see why in the ICSID cases, the test is set so high, because it has to be almost obvious if you look at it on just this one document, that's the case. But the approach taken in the SIC is different, in that one, you can have dismissal of both claims and defenses, and more importantly, you can take it at any time in the process. And I wonder, and I say this as I have an interest in this, and I'm actually sitting in a tribunal now, dealing with, I'm told by Kevin, one of the first, either the first or the second early dismissal application that was taken up under the rules. And I wonder whether the ICSID test would be applied the same way if you have the application taken up in a later stage in the process. Let's say, arbitrations can be conducted in many different ways, and you could have a situation where you have pleading, and then you have document requests, and then evidence, etc. It's taken up at the end of the pleading stage, which means that the case is quite fully fled. You've got all the facts, the law fled. Whether the test of many tests in that situation would be the same as you would have in the ICSID case, because by that time you've got the facts and the arguments before you. You've got a lot more material to look at. If you look at that material, you may come to the conclusion actually that the application should be granted, although you may not have come to that conclusion if it was taken at the very, very early stage of the process. I'm interested in thoughts and comments on this, whether anyone else has any views on this.
I mean, speaking under your control, but I think this procedure is not meant to be a duplicative jurisdiction phase where you miss your deadline to make a jurisdiction objection, and then at the 11th hour you make this type of application. And I would expect a tribunal to use its discretion, which is under the SIC rules and not under the ICSID rules, to actually not allow the application to proceed. And if the application is meant to, a late application would be to benefit for whatever the additional evidence has come up. I mean, it may very quickly not be the nature of the application which is envisaged by Rule 29.
Stephen, I think you've raised some very good points. I'm not completely convinced that it's a question of a different standard. Manifestly means one thing at one point and another thing at another point in an arbitration. But I think what might be manifest under the same standard could well be different at different times in the arbitration, precisely because parties have had an opportunity to put in factual and other submissions. One reason that we wanted the possibility of an application at any time during the arbitration is that it might, after a party has put in its entire case, become manifest that there was no legal basis for either a claim or a defense, given how the case had been put. That might not at all be manifest at the beginning of the case when all you had was the request for arbitration.
Thank you very much, Gary. I think Pranav has signaled that we should bring this to an end, but if I'm going to do a bit of crystal gazing, my guess is that you might see a lot more take-up of Rule 29 and a lot more cases being dealt with and even possibly succeed under Rule 29 than you would under the exit provision. And it's because of the very different way in which the SIC is approaching. I think that then brings us to the end of this. We end on this very positive note of leadership on the part of the SIC in terms of pushing the cutting edge of arbitration. It remains for me to ask the audience then to thank the panelists in the usual way.
Our next panel topic is the change phase of arbitration in India, story so far. The topic would be of immense interest and informative to everyone, especially our guests who are in our council. I would like to welcome on stage the moderator for the session, Mr. Mozum Khan, Co-Head International Disputes Practice, Nishidasai Associates. On the panel, we have Mr. Toby Landau, QC, Mr. Tejas Kharia, Partner Shardul Amarchand and Mangaldas, Mr. Bhaskar Chandran, Group President Legal GMR Group, Mr. Prakash Pillai, Partner Tyrant Classes Singapore, Mr. Lomesh Nidumuri, Partner Indus Law, and Mr. Niraj Tucker, Partner Economic Laws Practice. Before I begin, actually just a small point relating to the last session. It was on emergency interim relief. For those of you who are interested in seeing an emergency arbitrator or an emergency arbitrator proceedings in action, it will be done in this room itself tomorrow at 5:30 p.m. under the YSIEC Advocacy Workshop. I will now hand over the floor to Mozum.
Good afternoon, ladies and gentlemen. Let me first begin by thanking Siac and our sponsors for putting me in this unenviable position of moderating the last session. In this session, our esteemed panel will canvass the changed face of arbitration. If this were Justice Nariman, he would probably be able to narrate arbitration's history beginning from 16th century onwards, but I neither have his grace nor his eloquence and definitely not his knowledge. So I'll begin with the period between 1940 and 1996. Now, as all of us would know, India's arbitration landscape during this period was a potpourri of largely three legislations: the Arbitration Act 1940, the Foreign Awards Recognition and Enforcement Act 1961, and the Arbitration Protocol and Convention Act 1937. Now, the inadequacies of this potpourri created a sentiment of acute mistrust, not only amongst the litigants, but also amongst the legal philosophers. In fact, the Supreme Court far back in 1982 had remarked that the way in which proceedings under the Act are conducted and without exception challenged in courts has made the lawyers laugh and the legal philosophers weep. Now, from this, for the lack of a better word, petri dish of legislations, the Arbitration and Conciliation Act 1996 was born. And like any newborn, it had its teething problems, it had its mood swings of the teens, and as any parent would, the judiciary and legislature mollycoddled it and when needed, disciplined it. Now, the latest disciplining of this act, as we all know, came in the 2015 amendments. Now, sometimes I wonder what the situation would have been had the act and the jurisprudence did not evolve the way it did. In fact, I have it from a not so credible resource. In fact, my resources are hardly ever credible, but maybe Tejas can confirm it during the session, that one of the recommendations which did not make it to the 246th Law Commission report was to recognize right to reincarnation as a principle of natural justice, because one life was too short to initiate, complete, and realize actual money out of arbitration. So maybe Tejas, you'll have to comment on it later on. But now, ladies and gentlemen, without further ado, let me introduce our esteemed panel. To my immediate right, we have Mr. Toby Landau, QC, who's a barrister, arbitrator, and a member of the Bars of England and Wales, New York, British Virgin Islands, Northern Ireland, DIFC. And earlier this year, he became the first QC ever to be admitted as a full-time member of the Singapore Bar. He has won Legal 500 Award for Indian Arbitration Silk of the Year 2017 and was named most highly regarded individual in the International Arbitration in Who's Who Legal Global Survey 2015 and 2014. To his right, we have Mr. Tejas Karya, a known face in the Indian arbitration circle. He is a partner with over 15 years of experience and leads the arbitration practice of Sharadul Amarchand Mangaldas. He was part of the committee committee set up by the Law Commission of India for preparing a report on the amendments to the Arbitration and Conciliation Act, which culminated in the eventual 2015 amendment. To his right, we have Mr. Bhaskar Chandran. Bhaskar brings with him over 3 decades of rich experience in legal regulatory fields, in particular legal compliance, regulatory strategy, corporate governance, litigation management, secretarial and structured transactions in large and multinational companies. Bhaskar is currently the Group General Counsel of GMR, responsible for overall legal function spanning energy, airport and transportation and urban infrastructure sectors. To my left, we have Lomesh. Lomesh is a partner in Indus Law in the litigation and dispute resolution practice and has more than 13 years of experience in all aspects of dispute resolution, primarily complex civil, commercial litigation and arbitration matters, both domestic and international. To his left, we have Prakash. Prakash is a partner at Clyde & Co. Classes, Singapore, with his focus on dispute resolution and international commercial arbitration across a multitude of sectors, including corporate, commercial insolvency, trade and commodities, etc. Prakash also leads the insolvency practice in Singapore. He has also previously worked in Singapore Ministry of Foreign Affairs as a Foreign Service Officer and is the Honorary Consul of Republic of Iceland in Singapore. And lastly, we have Niraj Tucker. Niraj is a partner in the litigation and dispute resolution practice at ELP. He's a qualified lawyer with an additional attribute of being a solicitor non-practicing in England and Wales. Naresh is currently an active member in a number of professional organizations, including a Law Society UK, London Court of International Arbitration, IBA, and All India Federation of Tax Practitioners. And lastly, me, ladies and gentlemen, my name is Mauzam Khan. I co-head the International Disputes Practice and Nishid Desai, and I'm a member of the Siac committee with no other notable achievement. So let's get to it. Our topic today, the changed face of arbitration in India, the story so far. And at the end of our topic, time permitting, our panel will field questions from the audience. So without further ado, let's jump to the topic. Now, Lomesh, let me just begin by putting you on the spot. Let's begin with the changes brought about by the amendment to section, to section 29, by which 29A was inserted, which essentially mandated a period of 12 months extended by a further 6 months within which a final award has to be rendered. There's been a lot of debate around whether or not such harsh time period was an overkill. Now we're almost 2 years into the amendment. How successful have the arbitral tribunals been, in your opinion, in meeting this, some would say, harsh timeline? And do we now have any judicial precedents on this to take guidance on?
Thanks, Mauzam. Hello. Yeah, thank you. 29A of the Arbitration Act is obviously a very significant development. Arbitration regime in India was criticized for a long period of time, saying it would take too much time, it would just be like a regular court proceeding. 29A was a step in the right direction. But my concerns are this. The Law Commission report, when it gave the report, it gave suggestions insofar as making sweeping changes to the Act. Now, the timeline of 1 year plus 6 months was nowhere prescribed in the Law Commission report.
But the Parliament, for some reason, without any parliamentary debates, the only sort of person who spoke during the debate on the bill was Derek O'Brien, who just made some random comment, and that was about it. There was no intelligent sort of a discussion in the Parliament as to whether 1 year should be the guiding factor or should it be 2 years. So I would say to that extent, from a practical perspective, from what I see in the arbitrations today, one, it is actually interesting to see a lot of retired High Court and Supreme Court judges actually sort of panicking because they had to finish the arbitrations within a period of 1 year. So there's this palpable tension on everybody's faces saying, I cannot give you more adjournments. In a way, it was good because I think that's what Indian practitioners needed. They needed a whip to ensure that the arbitrations complete within time. But the question that I ask myself is, when you're proposing such a stringent timeline, are you doing it at the cost of the justice delivery mechanism itself being defeated? Because what typically happens is there are some complex arbitration disputes which would require a lot of time, construction disputes, etc. It is, even by international standards, it would not be possible for parties to complete it within a period of 1 year. So that, I think, has been a practical sort of a difficulty. Then the second aspect, insofar as the section itself is concerned, it's a very curiously worded section. So under the 1940 Act, there was party autonomy given to the parties where the parties could choose the time frame for completing the arbitration. But the Act said it's 4 months unless and until the parties otherwise agreed. The 1996 Act was silent on that. Now come the 2015 amendment. 2015 amendment says, hey, look, no party autonomy. I'm the legislature. I will decide that the arbitration proceedings need to complete within that particular period. So there could be debates sort of which could arise as to whether or not the legislature could sort of step into the party autonomy itself and take away their right. And then the other important aspect of 29A is with regard to party consent, because what it says is it's 1 year plus consent of the parties, it gets extended by 6 months. Now if you have, let's say, an institutional arbitration that is administering the proceedings, now if you look at section 2(6) of the Arbitration Act, which basically says the center to which that you adhere the rules to, they have the power to decide everything with regard to the arbitration. Now the question would arise as to merely by submitting yourself to an arbitration institution, have you also given away your right to consent and delegate that to the arbitral institution, where the arbitral institution itself will take a call whether to extend that period or not, whether they need to file application. So these are all some of the practical challenges which have happened, and the other aspect would obviously be confidentiality. Let's assume that parties have agreed to confidentiality in the arbitration proceedings. Now if you, after 1 year plus 6 months, you're required to file a petition in court. Now the court may say, I want to see what the sufficient cause is, I want to know what exactly happened, I want to see the documents. So then the confidential nature of the documents, the confidentiality, that may be compromised to some extent. So these are all some of the practical changes. And insofar as the judicial precedents that you asked me, there have not been any judgments on the point of 29A. I'm not aware of any challenges that have been made challenging the constitutional validity of it. India as a nation is notorious insofar as the writ petition regime is concerned, where they always seem to interfere with the commercial matters. I have not come across any precedent, but of course there have been arguments which have been made. There is a Delhi High Court judgment where the Delhi High Court basically said, though the new act would not apply, but considering that the essence of the arbitration regime today appears to be that everything needs to complete within a particular period of time. In that particular case, the arbitration had gone on for 16 years, and the court said, though stricto sensu, the new act does not apply, but let us apply the essence of it, and I'm going to give you an extension of only 6 months or 1 year. So that has typically been the broad regime insofar as 29A is concerned.
And Pages, correct me if I'm wrong. In fact, what the Law Commission report did prescribe was a time limit of 24 months to be extended by another 3 for giving the award.
So what actually happened in the Law Commission is that we deliberated this timeline issue for almost half a day. And ultimately, after the long discussion, we decided not to prescribe any timeline. And if you see the Law Commission report, there was no outer time limit. What in fact we had suggested is to have a time limit on each stage of arbitration. So for example, if you don't file your statement of claim within a particular period, then you cannot file it, or it will be deemed that you don't have a case, and the arbitration will come to an end. Likewise, it would be for every stage, statement of defense, evidence, and like that. So rather than putting an outer limit, we gave the autonomy to the parties to file their pleadings within a prescribed time, and we would have achieved the same outcome. But what we are doing is we are taking away the mandate of the tribunal by putting an outer limit. This was to be avoided, and that's the precise reason there was no timeline given in the suggestion given by the Law Commission.
Now, Prakash, if I can put you on the spot. You're often engaged to advise on India-seated arbitration issues. And is this mandatory time limit of 1 year extended by 6 months affecting decisions of parties at the time of entering into their respective agreements on whether or not to seat their arbitration in India?
Yeah, no, I think, I think it's, there's a bit of a perception issue here, you can see what they're trying to do, I mean, when listening to Lomesh's example of an arbitration that lasted for 16 years, India has, or had, I think it still has to some extent, a problem with that. There's massive amount of delay in arbitration. It has seeped into the culture, and it's a big, big problem. So here, there's a legislative attempt to try to solve that, to impose timelines. So you can see it signifies intent. The good side is that, yeah, it tells you that the Indian regime is serious, looking at it from an outsider's point of view. That, India is sort of waking up to the realization that it can't just allow things to carry on. It has to do something to speed up arbitrations. But, it has the other side to it, which is that it cuts into party autonomy. Lomesh brought up the practical issues. Yes, 12 months is a pretty short time for a complex arbitration. Even if you extend it to 18 months, sometimes, for big matters with plenty of facts in dispute, for instance, it may be a bit of a challenge. But, just looking at it from the point of view of principle, arbitration is a consensual process. Your parties are allowed, to tailor the process in the way that they see fit. And to have a one-size-fits-all type of thing, say 12 months, and impose it upon the parties, and then bring the court into play. So after 12 months, you have 6 months where you can consent, and then you have got to go to court to go and apply for extensions. So the court comes into play, and if you look at it from an outsider's point of view, that's not what arbitration is about. Courts are not there. Courts are there to help arbitration, but they're not there to supervise it and cut into party autonomy and impose timelines and things like that. I think that is quite, it creates a sort of perception that India has a problem with delay. It's attempting to find a solution by imposing such things, but it takes away or compromises party autonomy. And as a result, I don't really care as a foreign party what India's problem is. I would just move to another jurisdiction and say, Singapore has no such problem, London has no such problem. I'll just use them, rather than, be part of the problem. So I think that, while the intention is a good one, to try to solve the problem, I think at the end of the day, the resolution here must be a much, much deeper process. The arbitration culture in India must change. The stakeholders have to come together. Delay and so on, have to be removed. You've got to get the right people, the right institutions in place, all of that to get rid of delay, as opposed to legislation that puts it into a box and says you've got to finish it within 1 year.
Naresh, now, just to bring you in here, if I were to ask you to choose the two most significant changes brought in by our latest amendment in terms of the positive practical impact they've had since, which two would you choose?
So, you asked for two significant changes. I would actually put in three, give you a bonus at that. But, two significant changes which are positive. One is obviously that you have the interim relief now, which can be granted either by the court under Section 9 or by the arbitral tribunal under Section 17. So, in the post-Balco era, there was always this qualm with parties, not knowing what would happen to their interim relief if they wanted to approach the Indian courts. Will they get interim relief? And the answer really was no, because, during that point in time, and Balco made it very clear that the moment you opt out of Part 1, you are opting also out of Section 9. Once you've done that, then there was no way that you could actually go back to court for the interim relief. So, yes, that's a positive development. You also now have Section 17, where earlier under Section 17 you could approach the arbitral tribunal and the powers there were limited. Now Section 17 adopts all the other clauses of Section 9, and the reliefs as what are available under Section 9 are also available under Section 17. Additionally, you have also now given more teeth to the orders of the tribunal, because as against what would happen earlier, that the arbitral tribunal's order would not be enforceable until and unless the person would actually obey the order of the tribunal, you really couldn't do much about it. Now what has happened is that under Section 17, the orders of the tribunal do become order of a court and can be enforced as such. I have come across one practical difficulty, and there's this one decision of the Bombay High Court given very recently, where the High Court receiver was sought to be appointed by the arbitrator, by one of the arbitral tribunals for taking care of some property, and the issue arose before the High Court that can the High Court receiver really be used by the arbitral tribunal, or will it have to be a private receiver? The High Court obviously looked at various issues, including administrative issues, and has come to a conclusion that the High Court receiver cannot be appointed. It will actually have to be a private receiver as against a High Court receiver. Obviously, this is something which will have to be tested. The efficacy of having a private receiver is something that will have to be tested. So that is one part of the Act which is excellent. The other part is Section 36. We've always had this issue about enforcement. You know, you have an award and then that award gets challenged under 34. What do you do post that? You know, once that award is challenged, then for all times to come until such time as the award is either set aside and then you have a problem on your hand, or you know, the challenge to it is set aside and not allowed, that you really would be able to get the money in between. The time frame in between, what would happen is that there was all likelihood, and it has happened in many cases, all of us are aware of it, that the assets have been frittered away. So what do you do to protect that interest? And that is now actually brought in by way of Section 36, and that is excellent, because you know, now what Section 36 says is that the moment you challenge the award, it does not mean that there is an absolute stay, an absolute bar on any recovery proceeding. In fact, what will now happen is that if you want to avoid the award, you actually need to go and seek a stay of the award from the jurisdictional court, and if you don't get it, then you obviously, you know, you pay, and in the meantime, the enforcement proceedings can also go on. Also, if you were to follow Section 36 to the T, and which obviously the courts will have to, because Section 36 goes on to say, the last part of it actually says that the considerations before the court for while making an order under Section 36 would be the same as that of a civil court under the CPC, which means that the court will actually insist upon a form of a security, whether you give a bank guarantee or you give some sort of a property as a mortgage or whatever it may be, that the court actually decides, which means that you are secured. You as the judgment creditor are secured. So I do think that these are two provisions which are positive developments. We've spoken a lot about Section 29A, and we have spoken about the time limit of 12 months. I do think, and yes, there are many cons to it. But look at it from the positive side. Yes, we have been reactive. The entire change to the Act has been reactive. Every single change that you see in the Act is all reactive. So obviously, when you now see the change, you've seen the pendulum swing from one end to the other end. You now see the time limit, a time limit which has been brought in. If you look at it positively, what can I see? You know, what I see is that as against what was happening earlier, where, you know, arbitrators were taking their own sweet time to dish out awards, it is those very arbitrators who are actually pushing the button and who are pushing the parties to move with the arbitration. You also see the counsels, all the lawyers, all of us trying to finish arbitration within the given time. No one really wants to land up in the court. Neither does the arbitrator actually, want his name dragged in the court, nor do the counsels on either side actually want, someone to put a finger on them and say that, look, this entire thing happened because the counsels did not pursue the matter the way it ought to have been. And also, to some extent, the parties will feel the heat as well, because the courts are not going to be very easy to convince when you take application before them for the time limit to be extended. So I do believe that the positives out of that also, and I must add that, we may even see, and to some extent we are seeing that an arbitration bar is sort of developing. You will see arbitrators, many of them young, many who earlier were not even thought of. Suddenly you see them as arbitrators. And also, as I mentioned, you are seeing a bar of arbitrators also, of arbitration practitioners actually emerging. So these are positives out of this time limit, which has been brought into the Act.
Yeah, I mean, I actually agree with what Niraj has said. I think, one of the positive effects of the legislation would be it would change behavior within India. When you have legislation like that, there would be then an impetus for you to sort of do things quickly and correct the deficiency in international arbitration, or arbitration, which is that of delay. But you have to also look at it from a global point of view. What is the point of this legislation? To attract international arbitration to India. Now, would international arbitration foreign party choose India when you have legislation like that? With the issues of party autonomy, with the issue which I think, the fact that it showcases the problem, that India has a problem with delay. So I kind of actually agree with Sri Krishna's report, where he says that maybe what you can do is to have this regime for domestic arbitrations. So it's useful as a tool within India, change things, correct things, make things faster. But if you're attempting to bring international arbitration into India, you've got to look at it from a foreign party's point of view. Would a foreign party want to immerse in an environment where you have to finish everything within 12 months? Because otherwise, there's a big problem with delay. As I said, I think that is possibly a disincentive. So I would tend to agree with Sri Krishna. Use this regime, but for domestic arbitrations.
Now let's get Bhaskar from GMR on this. Bhaskar, you've heard Prakash speak about how this, an amendment like 29A could probably take arbitrations out of India. And you've been at the helm of legal departments across various, Indian corporate powerhouses. And as a Group General Counsel, GMR would see, or probably be negotiating arbitration clauses day in and day out. How do you think have the amendments affected the negotiating power of an Indian company when it comes to an arbitration clause? And particularly, do you feel more empowered to argue or negotiate that because of these amendments, we can now seat at arbitration in India, or do you agree with what Prakash is saying on the other side?
Thanks, Mozam. And my response is purely from the perspective of the user, or from a not from a law firm or but from a user standpoint. To us, when we look at these arbitrations, one of the big constraints that we have, we look at cost as one big constraint, and therefore one would tend to argue, okay, why not we do these arbitrations in India, and where it is much more cheaper. But having said that, the answer to this question is that do we have the requisite the infrastructure? Do we have the legislations to support? Do we have the legal system to back it up? If I have to answer this question probably about 5 years back, maybe my answer would be slightly different. But with the current amendments, what we have seen, and the positive developments, what we have seen through the amendments, and what's happening in the judicial and the arbitration space, I feel more confident than before. And from a GMR perspective, contracts is our lifeline. And then we, as we are into airports in India, abroad, we do energy business, we are into transfer. We day in and day out, we execute contracts, both domestic and also with international parties. While I negotiate a contract with an international party, the key question that always comes up, right, when we make a proposal, why not we do the arbitration in India? The transparency, that was a big question, that we used to have. I don't have a specific answer to this, but at least I have an argument to make at this point of time. The positive things that I talk about are the changes in the arbitration regime that has happened. Pre-arbitral proceedings, arbitral proceedings, post. Pre-arbitral proceedings in terms of the independence and the impartiality of the arbitrators. The amount of disclosure the arbitrators need to make at this point of time is exceptional. One, get to know whether this person has given an opinion to them or they have acted as a legal advisor to the party, and so on and so forth. So therefore, there has been a lot, I would say a transparent position that is emerging at this point of time. In the past, like for example, a contract with the government agency, the chief general manager would be the arbitrator here. Those sort of things no longer exist today. We have moved far too ahead at this point of time. We have moved our system to align with the international best practices at this point of time. We talked about even a foreign seated arbitral award. One can go to an Indian court and then seek an interim relief at this point of time. So therefore, somebody asking, somebody is saying this, no, we don't want you to be before an Indian jurisdiction, that no longer exists because the law is very clear at this point of time. Expeditious disposal we talked about, and we talked about why, when an Indian arbitration can be done in 12/18 months, why can't a foreign arbitration be not done in 18 months? That's a key question, right? Today, the point is that it is the arbitrations that I have seen over the last several years, it's about most of the times where we end up is not because of the lack of preparation, it's because of lack of availability, lack of time constraints that we used to get with the arbitrators and so on and so forth. So I guess with all these positive amendments that have come, today when I negotiate a contract, yes, I am in a much better position to make a proposition, but having said that, with all my international parties, I don't have an arbitration, seated in India. Everything is Singapore at this point of time for me. So when I look at it, what is it that we need to do at this point of time? In my view, why is the foreign seated is more preferred, apart from the transparency, apart from the unbiased that we talk about. I guess that there is a lot many things that we need to do in India, creating the infrastructure. You go to Maxwell chambers, outstanding, everything is set. Arbitration would start at 10 o'clock in the morning. Arbitration in India would start at 11 o'clock in the morning. Arbitration will go till 5 in the evening. It will end at 4 here. So there are a lot many more changes that we need to bring about. In my view, are we on the right track? The answer is yes. If we bring about these changes, I am pretty positive that I would be able to, when I negotiate my contract, I would be able to say, no, Indian system, Indian seated arbitration is no less compared to the other jurisdictions. Probably, in my view, and if my wish goes, well, we may not be even have this question 5 years from now. And today we are having that question. Probably this question may not be there in somebody's mind 5 years from now as well.
Just one last comment from me on this. So, us Indians are rational thinkers but irrational actors, and I think that's how this is played out. So we had a very rational thinker amongst us, Mr. Karya, sitting with us, who was a part of that committee, and we heard from him that this was not something which was proposed, but something which has come in. On the issue whether, Lomesh, you mentioned that this is not something, this provision you've not seen tested in courts. Just one comment on that. I've seen firsthand this issue being dealt with by the tribunal and then also by the court. The tribunal in one of my cases, what they did was they started off by telling both the parties, look, let's start with 18-month period. So right away, 12 months plus 6 months, you guys have to agree even before the arbitration begins. So you start off with the 18-month period, and unless you start off, we aren't actually moving on with this matter. So that's how it started off. In the courts in Mumbai, this issue did arise, and once the 12-month period had got over, one of the parties, obviously the respondent did not agree to the 6-month extension, and this matter landed up in the court there. And the court actually asked the other side that, what really happened in the arbitration. There was a lot of hesitation, and when this issue was brought up, really not much was said, but the court sort of understood, and it just granted the 6-month period without getting into the issue of who actually delayed the entire process. Was it the claimant? Was it the respondent? Was it because of the lawyers, or was it because of the parties themselves or the arbitrators?
Actually, Naresh, I agree with you. I think as far as the tribunals are going, a lot of the domestic tribunals are now starting off in their first procedural hearing to get the parties to agree that let's extend 12 to 18. And possibly the way Bombay High Court reacted is how we will see courts reacting in future as well. Now, in the context of enforcement of foreign awards, Toby, if I can just bring you in. Do you feel that our enforcement regime requires an overhaul, or are we doing okay the way we are?
Overhaul. But I can elaborate.
Please do.
When one thinks about enforcement regimes, obviously one is concerned with the implementation of the New York Convention, and in particular Article 5 of the New York Convention, which sets out the exclusive grounds upon which recognition and enforcement can be defeated. Now, I speak from some experience because I am developing a sub-specialty in my profession, which is traveling the world defeating arbitration awards, which is a growth area. And that teaches one about what is needed for an effective enforcement system. One has to think of it in terms of, firstly, process, and secondly, substance and harmonization. Now, in terms of process, what is critical when you've survived the whole arbitration procedure is to have a fast-track, streamlined system before national courts for recognition and enforcement. None of those adjectives, I think, yet apply to India. I think there are aspirations, but the truth of the matter is that it is not fast, it is not as streamlined as it might be, and therefore, even if you've got a very fast, posh arbitration, you might still slow down. The whole process might get defeated when you get to the end and the all-important area of recognition and enforcement. On the substance, the critical point is that Article 5 is implemented as it should be and harmonized with Article 5's implementation by other jurisdictions. Now, when one thinks about this, it's not just about limiting the grounds in Article 5. One talks about pro-arbitration policy. Pro-arbitration can sometimes mean not defeating arbitration awards, and that means not applying an overly expansive interpretation to the Article 5 grounds. But pro-arbitration can also mean not reducing Article 5 too much, because Article 5 represents an irreducible core of guarantees and safeguards. So it can be, and this is what I often tell courts, it can be pro-arbitration not to recognize and enforce manifestly flawed arbitration awards. So if you pull all of that together, what is very, very important is that the recognizing and enforcing court is as well informed and educated as possible in applying the Article 5 grounds. Now, if I was given the opportunity to say what should happen in India, what would be on my wish list, if I ruled India, which is not at the moment an impending scenario, let me just comfort you, there are 4 points that I would identify. The first one is there should be, ideally, in an ideal world, a fast-track procedure. It should not be a system that goes into a normal civil process and takes a year, or a year and a half, or possibly 2 years. So the first one would be to actually set up a streamlined process that's directing all applications to specified courts through a fast-track process. That's number one. Now, number 2 is a little bit awkward. Number 2 involves specialized commercial benches which are manned by specialized, well-trained judges. This is why this gets a little bit tricky, because what I'm about to say will be considered as contempt by a large portion of the judiciary. Judges around the world tend to be reluctant to admit that they could be educated or re-educated. That is something which we have got over in many countries. For example, in England, for example, Singapore, where judges are regularly going through education processes and training. But in many other countries, it's considered inappropriate to suggest to a judge that they should go for training. So in the Sri Krishna report, there is a masterful diplomatic expression which is called refreshing. That's what it talks about. Refreshing judges' knowledge of an area. Now, refreshing presumes that initially the judges are already fresh, so that you refresh them. That is often an unsafe assumption all around the world. What is critical to effective recognition and enforcement is to have judges who are prepared to be trained, and that they are kept up to speed, and that they are kept informed, and therefore to actually breathe life into what is already the structure here of commercial specialized benches. That is absolutely vital. Point number 3, there needs to be, not just in India, most places, there needs to be an institutionalized system whereby courts expect to receive international input in their decision-making on recognition and enforcement. That is, they expect to be shown international materials on Article 5 and its implementation, whether that's by way of international textbooks, articles, whether it's by way of commentaries, whether it's by way of accessing resources that are available, for example, the ICA roadshow, the training judges, and the materials that that has given rise to. In some countries, for example, in Singapore, the International Arbitration Act there actually makes specific reference to the use of international materials, travaux preparatoires, so that the vital thing is that the court proceeds not in a bubble. It's got to be integrated and plugged into international experience. Many countries are doing this. Some are more successful than others. Very, very briefly, not to take too much time, but I can't resist it. Even in Pakistan, they are now using experts to assist them in their applications under New York Convention. Now, I know this because I was the first expert who was called before the Lahore High Court about 4 years ago for the first application in Pakistan for recognition enforcement under the New York Convention. And the idea was that I would testify to the court on the meaning of public policy under Article 5 of the New York Convention internationally. This was a complete disaster, I have to tell you, but it was well-intentioned on the part of the Lahore High Court because they were ready to receive input. It was a disaster, just to quickly tell you, because the court was not set up to actually deal with this expertise. So there was nobody actually to cross-examine me who knew anything about the New York Convention. So I put in an expert report, which was all about how Article 5 is implemented, and the first person that they had to come out and cross-examine me knew nothing about international law and treated me rather like a murder suspect, which actually which led to a devastating cross-examination, which I couldn't actually answer at all. His first question was, where were you on the day that you claim you qualified as a barrister? To which I had no answer, which was pretty impressive. So this went on for some period of time, And actually what happened at the end of that was that there was a judge who was a brilliant innovator procedurally, and he suspended the cross-examination on the basis that it wasn't helping him at all with respect to the New York Convention, and he then gave a procedural direction which was, Mr. Landau, would you mind asking yourself some questions? At which point I then proceeded to cross-examine myself on the New York Convention in front of the Lahore High Court, by which point the court was packed full of everybody who had left their own cases to watch this spectacle. Now, this is all completely irrelevant, except to tell you that even Lahore is making an attempt to inform itself, and this is something which one comes across all through the world of the New York Convention. It's vital that courts are linked up and that they actually see what's happening internationally and conform and harmonize. And the last point in my 4 points in my wish list is that there should be implemented adverse costs orders for frivolous applications to resist recognition and enforcement. And there are 3 different forms of this. The first one is simply implementing, which is already there in, I think, well, certainly there in the Sri Krishna report, adverse costs order, which is that if you do not succeed in resisting recognition and enforcement, then you pay the costs. But the second one, which is much more of an incentive not to mess around, are indemnity costs. If you make defenses, you pursue defenses that you ought not to pursue, then you should be liable for indemnity costs. And the third one, which is the last one and the least popular, which we do have now in England, is wasted costs. Wasted costs is a phenomena which is perhaps will take some time to come, but it's incredibly powerful. And that is an order that the court can make against counsel personally for wasting the court's time. If the court feels that in fact an application or grounds have been put forward that should never have been put forward. And that stops people simply trying their luck, and in trying their luck, delaying the system and thereby defeating it. That's my wish list. Thank you.
Just want to add one point to... Hello. Yeah, just want to add one point to what Toby was saying. In fact, from the Indian regime perspective, the Law Commission report had clearly said that insofar as enforcement of foreign awards are concerned, there should be a time limit of 1 year in order to decide the challenge, because a similar provision was also introduced insofar as the domestic award is concerned, where there's a time limit of 1 year. But for some strange reason, though the Law Commission report had suggested this, it does not find a mention in the Act. So as of today, just to add to Toby's point, we don't have a legislative mechanism where enforcement of a foreign arbitral award would be decided within a specific period, even though the Law Commission report had suggested that.
I was actually going to make the same point. When you set time limits left, right, and center, it's sort of it's very strange that there's this omission, because when it comes to enforcement, this is where you'd want a timeline. Toby talks about an expedited sort of procedure for this, but, at least have something, some sort of time frame. For setting aside a reward, you have 1 year, and to conduct an arbitration, you have 1 year. But how come nothing for enforcing a foreign award? At least say, endeavor 1 year. I mean, in Toby's wish list, it should be even faster, which I agree with. But say something about it. It's a glaring omission in the amendments.
Now, Toby said something really interesting. That a pro-arbitration approach sometimes can mean not to enforce manifestly wrong awards or manifestly erroneous awards. Now, this is the first time I'm thinking about it this way. But one of the many interesting statistics that keeps coming up is that in fact in India, in probably the last 5 years, there hasn't been a single foreign award which has been refused enforcement, except one which probably was there from the Nagpur bench. But other than that, in the last 5 years, there hasn't been a single foreign award which has been refused enforcement. So perhaps the being pro-arbitration may not be the root of the problem. Perhaps the problem really is, as Toby was saying, and as Prakash supplemented, the time that we are taking from receiving the award to ultimately getting the money. And unfortunately or fortunately, different proponents will view it differently. the mechanism of execution, or the mechanism of actually, attaching and selling properties and recovering your awarded amount doesn't really happen under the Arbitration and Conciliation Act in India. So once your award is recognized, then you get into the execution mechanism as prescribed under our Civil Procedure Code. And your award will, even if it's a foreign award, will be executed just like any other decree would be executed in India. And at least from where we're sitting right now, even if that execution gets completed in 1 year, I'd be really happy. But currently, I think the timeline is somewhere about 2 to 3 years for that second stage to get completed. Now, this is where I want Bhaskar, you to come in. Have you noticed any change in the attitude of Indian courts when it comes to enforcement of awards? And do you believe specifically that even within India there are certain jurisdictions which could be better than others?
The answer is enforcement of awards. Yes, of course, it's a difficult proposition. But having said that, I see a sort of a marked difference in jurisdictions like Delhi for sure, and Delhi and Mumbai, where we have enforced awards in these jurisdictions, say within about 18 months or so, right from the start to the end. Similarly, there are places where we are even struggling after about 2.5 years outside of Delhi and Mumbai. I guess the reasons for that would be, the commercial courts, that have come up, and the judiciary and the legal system, is probably much, I would say, stronger in these jurisdictions. Also, the one is the time aspect of it, and second aspect is how the courts react to these things. Like I was enforcing an award in one of the southern states, and it was about some 300 plus crores. They had real difficulty to understand this much big amounts, those sort of things. But you don't see these sort of issues in a Delhi or a Mumbai high courts. And very clearly, in my view, if there is a way, and this is purely from a practical standpoint, and there are various ways and means of you probably choosing a jurisdiction. I think the practical aspect of it is that there are various asset recovering companies, asset identifying companies, which can identify the assets where the respondents, assets would lie. If there is, if you, this question arises, if you have about multiple jurisdictions you can come out with, and if the assets are in about 3 or 4 jurisdictions, and even if it is a much lesser amount, in a Delhi or a Mumbai, if there is a way that you could bring up in these jurisdictions, it could be faster and it could be more prudent to do so.
I think for the evening I'm the flag bearer for India, so let me continue in the same vein. I think I really don't think this can be resolved. This issue about enforcement actually can be resolved from the point of view of arbitration. It actually needs a overhaul of the system. You can't have a arbitral award being enforced within a given time frame, let's say a year or 6 months or a month or whatever, and every other order of the court or a decree of the court taking its own sweet time of 2 to 3 years. Because obviously then it will become what we all, at least in India, recognize as an Article 14 issue of discrimination between what we have in arbitration and what we'll have in court. So really speaking, this is something which will have to be looked at as a larger picture. You need to look at it from all India perspective, and also we must bear in mind that we have 24 high courts and we have various other district courts under those high courts. So when we talk about judicial, the refreshment issue that Toby spoke of, and which obviously the Sri Krishna Commission talks about, then obviously that has to start at the grassroots level. And when I say grassroots level, all the district court judges first need to come up to speed with this, and then you can really expect all these issues to be addressed, because without that, I don't think we'll have, whether arbitration or otherwise, I don't think we are going to see any improvement.
Now, I think one thing that I'm curious to know, and Toby, perhaps you're the best person to answer, and after that maybe Prakash, what is it that courts in, let's say, Singapore and the UK are doing differently, which enables them to, recover their monies within 6 months or 8 months or 1 year of beginning enforcement proceedings? What are they doing differently?
You have to make a distinction between, on the one hand, recognition and enforcement and execution. So there's an important distinction there. For recognition and enforcement, which is governed by the New York Convention, execution is not. That is itself the subject of a very streamlined process. So that comes within the realm of arbitration applications, different from execution, which is just in the general process. So once you're in the realm of arbitration applications, recognition and enforcement, like all other arbitration applications, is the subject of a special chapter of our Civil Procedural Code, whereby you have fast access to the court, where there is a mandate not to delay, and where there is, as I was saying before, the court is very much plugged into, both now in England and very much in Singapore, plugged into the international harmonized approach, so that there isn't much chance of delaying. If you want to delay by raising spurious grounds, then the chances are you're just going to end up with either it being struck out, or you're going to end up with having to pay the amount of the award into court as security in order to, as a condition for proceeding with your attempt to defeat the award. So all of those mechanisms are in place to make that process, which simply doesn't take very long. When you then step out of the arbitration sphere and move into execution, then you're into just general civil process. And it's just, I think that is a function of the huge amount of work that's gone on over the years to promote and streamline commercial court process and general, as we would say in England, general high court process, and in Singapore also. And that is just general civil procedural reform, where execution can happen very quickly, judges are accessible, applications simply don't take long. But I think one has to see it as those two tracks, and it's quite right to say that it's difficult to think of a special execution process just for arbitration. In order to improve the execution process, that probably is a bigger prospect that goes way beyond just arbitration.
Thanks, Toby. Now, Tejas, you were one of the architects of the 246 Law Commission report, which ultimately led on to the amendments. And now we've had 2 years of practically living with these amendments. Is there any part of the amendments that you're disappointed with, or anything that you feel could have been done differently, or something which was left out either from the report or from the amendments?
Yes and no both, because there is no disappointment coming out of the amendment, because it has changed the landscape of India in arbitration world, and it has led to a lot of positive developments in field of arbitration. So there is no disappointment as such, but things could have been done better. We had put in a lot of effort in bringing about all the changes which were required. Some came through, some did not. To start with the topic which we are just discussing about enforcement, of course there was a suggestion that there should be a time limit put in there. Somehow it has not been put in. I think it's just by way of an inadvertence that time limit is not there, because it came in for part 1 and it got missed out for part 2. So in the next round, after the Justice Sri Krishna Committee report, it would be introduced. So that's not a big challenge as I see it, because it's just that we need to introduce it. But is it enough? We need to really think of, as Naresh says, changing the entire system. And I have a slight disagreement with Naresh on this, is you cannot compare arbitration with other civil litigation, because the parties have chosen arbitration as their preferred mode of dispute resolution. And I was asked this question by some of the High Court judges when I had gone to Bhopal Judicial Academy to address them on recent development of arbitration. They asked, what is so different about arbitration that we have to fast track it? What is there in what is problem in other litigation? But the real issue which we face is there is a continuance of commercial relationship. At the end of the day, commercial disputes should be treated differently from other disputes, and that's the way other jurisdictions are treating, and we have recently started dealing with it. Both Commercial Courts Act and the Arbitration Amendment came on the same day, and that has also changed quite a few things. The commercial judges, Commercial Division of High Court and Commercial Appellate Division are making every effort to expedite the enforcement or anything related to the arbitration. Even Section 34 applications are decided in Delhi High Court at the very first hearing. So I was before the Delhi High Court thinking that notice will be issued and the other side will file reply, and judges after half an hour said, continue, why are you stopping, finish your argument. So I said, but notice? He said, no notice, we are deciding it finally. So that's the mindset change we are looking for, and that has come in some parts. There was an enforcement application which we had filed for an LTIA award in Gujarat High Court. We got a favorable order. The other side filed an appeal with a Commercial Appellate Division, which just decided 2 days back. The Commercial Appellate Division said no, it is not the Commercial Act would apply, but the arbitration, which is a complete code, will have an applicability, and Section 50 prohibits an appeal against an enforcement of an award. And therefore, even though there is an ambiguity between Commercial Court Act and Arbitration Act, the Arbitration Act would prevail. So that is another change which we can think of, and which the Justice Sri Krishna Committee has already suggested, it to add before Section 37 and 50, that notwithstanding any other law for the time being in force. So therefore, even though Commercial Act, Courts Act provides for an intra-court appeal from division to the appellate division, that would not be permissible if it is an arbitration matter. The another thing which was suggested in the Law Commission was recognition of emergency arbitrator. All the other jurisdictions have the legislation which recognize emergency arbitrator, and we don't know reason why it was not introduced. In fact, it would have increased the institutional arbitrations in India, and that was the motive behind all these amendments. And only thing which was to be done is to define the arbitral tribunal, which includes emergency arbitrator, and by that implication, even the orders passed by emergency arbitrator would have become enforceable as a deemed order of the court. So those things were also necessary. The other thing which could have been clarified is the applicability of the amendment. A lot of litigation is happening on that aspect, which is also now in the second round of amendments is suggested to clarify, to mean that unless parties otherwise agree, the amended provisions will not apply to the pending arbitration, because that is something which is creating confusion for the court matters, the arbitration related matters which are pending before the court. So these are the few further amendments which we can think of. There were other small issues, but as I see, these are the major things which we can think of, other than changing the mindset, which I feel has started to happen. It has increased the base of arbitrators. The younger arbitrators are getting opportunity to be appointed. Former judges, with due respect, are declining the appointments. They are saying that we are too busy to finish arbitrations within 1 year. And much has been talked about for 1 year. I have already intervened on that. But what it could still be considered is that if we were to continue with the 1 year timeline, the extension power should be given to arbitral institutions rather than to the court, because the court intervention was to be reduced, and there is no need for court to get into this entire debate about who is at fault and how much extension should be granted. That can be easily be given to the arbitral institution, like we can have it under Section 11 for the appointment of the arbitrators. Even the extension should be given to the arbitral institution, which would give a lot of importance and encouragement to the arbitral institution to come in and perform their role even for the arbitration which are not administered by them. So those are some suggestions which I can think of. We can still consider and improve the arbitration scene in India.
So while we're on this report, Prakash, very quickly, as a foreign practitioner, what are your thoughts on one of the interesting recommendations in Justice Sri Krishna committee report about grading of arbitral institutions and establishment of Arbitration Promotion Council of India?
Well, I can't say that I'm in favor of creating a bureaucratic structure like a council, where and starts sort of hiring people. I suppose there'll be lots of jobs for retired judges and so on, to do this sort of accreditation. I think what India needs is a flagship institution, a bit like Singapore having Siac, India and China has CTAC. India should pick one. It has MCIA, which seems to be a glimmer of hope. The Sri Krishna report talks about the International Convention on Alternative Dispute Resolution, ICADR, and it's sort of, it sort of says that should be the flagship. I think that's the way to go. Build up ICADR, make it like a CTAC. India is a vast country like China, split it into various commissions to deal with the various states, the different regions, and that would be the institution that could be the appointing authority under your act. A bit like Siac is the appointing authority under the Singapore International Arbitration Act. So I'm not in favor of this accreditation and all of that, simply because I think there's just too many players in the market doing lots of nothing, really. There are 35 arbitral institutions, Sri Krishna's report points out, and they're largely ineffectual. So to create a structure and then start accreditation and all of that, I think you should actually pick a flagship one, make it work. Then you get, just like Siac, we have our senior minister of state, you get a minister for law to back it, to go around the world selling it, talking about the regime changes in India, talking about the flagship institution, talking about the rules, our best practices, consultation with the arbitration community around the world. Focus on this flagship institution. And I think then, things will improve quite considerably. Rather than creating a bureaucratic structure, getting more and more activity, generating more, encouraging the multiplicity of arbitral institutions, I think, frankly, that's not going to get you very far.
Yeah, just to give a different perspective, I was fortunate to be part of Justice Sri Krishna committee also, and we deliberated this dilemma of having one institution versus multiple institutions. And the outcome of the discussion was, after taking the feedback from all the stakeholders, is that it's too difficult, given the size of India, to have one institution. We need to have at least uniformity amongst all the existing institution, and also have, as what Prakash says, is that flagship institution which can be taken over. And ICADR was one which is available institution which has the infrastructure, and Supreme Court had shown interest in taking it over. And that the process is still on, and there is a committee which has been formed by the Supreme Court to do a complete overhaul of the institution. The difficulty is we are comparing India with Singapore and London, where we don't have a kind of a activity happening at one level. MCIA is doing good because Mumbai is a financial hub, and we can definitely improve the arbitration scene in Mumbai. But if you are talking about India, there are thousands of ad hoc arbitration happening every day, and we need to be really focused on institutionalizing it and uniformly applying the rules to all the institutions. That's where the model rules are also suggested to be added in the Act itself, which will then govern the arbitration process, even though it is an ad hoc arbitration. And this accreditation will really help to identify the arbitrators who are really good and they can have a continuous learning experience to be appointed as an arbitrator. And that is the whole idea, is to promote. It's more of giving a training and recognizing the arbitrators and creating a pool of arbitrator or arbitration bar, so to say, in India. And we have a chartered institution of arbitrators which imparts training, and they have different levels of courses. Like that, if we have a council, not to control the arbitration scene, but it's to promote arbitration. And that's why the word used is promotion council. And that was the thought behind it. And I agree with Prakash that there should not be bureaucracy into it and too much of technical processes involved in it. But there should be a body which would then ensure that the institutions are performing the way it should perform, and if not, then they should be corrective measures should be taken to bring them at par with other institutions. So that is the sum and substance of Justice Sri Krishna's recommendation on Promotion Council, Arbitration Promotion Council.
Just to very quickly respond to that, I knew Tejas would say that you can't compare India with Singapore because one is an elephant and the other is a peanut, but I'm also comparing India with China. I mean, Siac is their flagship institution, and China is bigger than India, and it's worked pretty successfully over there. But I mean, you can take the point that it's a different type of country, but I still think that that model will work best, at least as the starting point. Instead of having this very confusing myriad of different types of institutions, most of whom are doing not very well. Focus on one thing, build it up the way that China has built up CTAC. Make that your flagship institution. Use that as the example. I mean, if you don't think that Singapore will work for you, look at another big country, and China is a good example of that. Sorry.
Yeah, so I think before I move on to the next question, I think there was certain problems that even CTAC had faced, in the middle somewhere because of defranchising and things like that, and it's now kind of rebuilding itself. But point taken, Prakash. Toby, to conclude with the big question of the night, has India's perception in the international arbitral community changed, be it as a seat of arbitration or a jurisdiction where enforcement is sought?
I think there are two aspects to this, a positive and a negative. So the positive is that for sure a new message is coming out of India in terms of the international perception. India has grappled incredibly successfully with identifying what the problems are. There's a long legacy in India, not just India, in the whole region, Bangladesh, in Pakistan, in Sri Lanka, a long legacy of difficulties in implementing a successful arbitration system. And the problems, specific problems in India have now been identified, and there is an extraordinary momentum that's coming now from India with the 2015 amendments, with the Sri Krishna report, with the level of activity and the level of goodwill that everybody has to actually solve the problems. And that is a message which is definitely being perceived. Now that is the end of the positive section. Without wanting to overly undermine anybody's morale, the reality is that this is always going to be a long journey, and India has not yet, of course, arrived. And it would be extraordinary if it was able to neutralize that long legacy so quickly. So it will take time, and the reality is, at the moment, the harsh reality is, India is still perceived as an unsafe jurisdiction for arbitration. The reason for that is that there are still, of course, multiple cases. People have multiple experiences where things have not worked out here in a way that perhaps they might. And one of the problems, of course, is when you've got a country as large and diverse as this, very often what will happen is you've got goodwill at the top, but when it filters down, you've got people acting at lower court levels or regional high courts, or people who actually are still very much imbued with the old way of doing things. So that what happens is that the system will correct itself, but it will only do so on appeal. And that's not good enough, because in the meantime you get caught up in lower courts or regional courts where issues are unresolved, where you have problematic decisions, and then you've got to fight your way through to get a proper corrected decision on appeal. And that is a major disincentive for people to come here and seek their arbitrations here. There are still problematic decisions in terms of an overly interventionist bench judiciary, but also there's a problem of the mindset of counsel. Because counsel very often, if they will treat this in the way that they've always treated it, which is if there's a problem, we'll go to court, we'll get an injunction, we'll slow it down, we've got these tactics, we've got these ways of doing things. And so ultimately where this leads, which I think is a common experience internationally, is you can legislate as much as you want. And India is doing, I think now, some very successful, very intelligent, if I may say, legislating. But for every jurisdiction, the limit is you can say what you want in the law, but you've got to actually change hearts and minds. And those are hearts and minds of the judiciary, they are hearts and minds of lawyers, and also of users. And that is really puts the focus not so much on legislation, but on training and education, and creating an environment where people buy into this sort of model of arbitration. And that is something which necessarily takes time. We are still grappling with that in England. There are key examples where we try to legislate minds and hearts in England, and that's not been successful to change attitudes. So it's not just a South Asian phenomena, it's a natural phenomena. But coming back to more of the positive, my own sense is that in a very short space of time, India has suddenly turned a corner and seems to be now on a path that, all being well, will actually lead to a great and bright future.
We have time for fielding a couple of questions from the audience. So there's a lady, there's a gentleman.
Well, my name is Gill. I'm a maritime arbitrator, but admirer of arbitration. Chairman, you conducted the panel so well that many good points have come out. My worry is when you said 18 months or 12 months, India is known for notoriously for this long delays in court and everything. I think it was a good thing that they have brought it itself. Now, only reason why it is not being liked, our trial, our arbitration is like a trial. We must look at it, what they do in other countries. Now, I found the maritime arbitration angle abroad, and they don't treat it like a trial. Here we are treating it like a trial, like any other case. Number two, we have had an amendment in 2015. Now, we forgot about the 2006 Untitled amendment totally. Interim award related issue and our award practices in line with the international practices. Now, we have Sri Krishna's report coming in. It is again going through many points. Now, by the time we see the horizon, we have another proposal going on, Mediation Act. So we are really struggling, still not clear where we have to go. Like Mr. Karya said, at least whatever has been done, implemented. So with this I can say that yes, we have a reason to improve further. Only thing is that do not treat arbitration like a trial. I'm with the
Point taken, sir. I don't think anybody on this panel will disagree. Yeah.
Dear panelists, I want to know only one thing. In Siac Rule 5, Expedited Procedure is there only, and I want to know whether it is not compulsory in the Siac Rule to finish it in a given time. Only this Rule 5 is there. Will you please explain it, what the party will do to go in this Rule 5 in Siac Rules? Regarding Rule 5, yeah.
So I think this is a point which the gentleman standing right behind you, Pranav, who's the Asia head for Siac, can field. And he can take it maybe, over drinks. Any other question? One last question, and then we call it quits. The gentleman right here. Oh, okay. We'll take 2 more then.
I have a question.
But you'll have to be concise, ma'am.
Yeah, I'm Girija Krishnan Verma. I'm an attorney as well as an arbitrator. I have a question for Mr. Toby. And the question is that, is there something, do you have a suggestion, is there something that the arbitrator can do differently while writing the award to ensure execution of the award?
So you're saying it's something the arbitrator can do?
Yeah, when writing the award to ensure its execution.
To ensure its execution?
Yes.
Write the award well.
No, but how do you ensure its execution?
So there isn't, I mean, there is, as a matter of common law, the tribunal doesn't have jurisdiction to deal. All that the tribunal can do is to minimize the prospect of challenges or defenses to recognition and enforcement. And that's really part of the tribunal's duty. It's a duty which is made express in many sets of institutional rules, that the tribunal must not only decide the dispute, but must do everything possible to make sure that the decision in the end is enforceable. And that means that's part of the mandate of the tribunal, and that's a question of foreshadowing what might be defenses to recognition and enforcement. So when an arbitrator drafts the award, you should, as when you're counsel, always be working backwards, which is you should have in mind Article 5 of the New York Convention if it's an international case, and you should be drafting accordingly to make sure that there aren't any possible objections that can be made later, or if the objections are made, that they are bound to fail. In terms of actual execution, that isn't really something which is going to be within the tribunal's purview.
Can you guys hear me? Yeah. Okay. So it'll be interesting to know what the panel thinks in it, and also in context of the fact that India is primarily a capital importing state. What do you guys think about the fact that should we be thinking about third-party funding, or is it still time before we start thinking about that?
So your question is on whether or not we're ready for third-party funding?
That is correct.
It's a dilemma which is going on for quite some time. Now the issue comes is that there is no prohibition for third-party funding in India. But the question comes when it comes for enforcement and whether it would be treated as a maintenance and champerty which is prohibited under the common law. And that is where the Indian parties are getting third-party funding when that enforcement is not going to be in India. So that's the start of it. But like Singapore and Hong Kong has recently changed their law, we will have to amend the law, because I was sitting in similar panel where one of the distinguished judges of our Supreme Court says that a vacuum is not against public policy of India. So when it's not tested so far, because nobody takes that chance of getting an award, and nobody will fund Indian party because they know that they are not going to recover that money if the award doesn't get enforced. But there is a one view, which is a possible view, that there is a vacuum in a law, and that may not be treated as a violation of public policy of India. But we have to wait for a case where a third-party funder takes a chance. But your question is it a right time to change the law? I think yes, because if it is internationally recognized process, and there is no way anybody is getting interested in the matter. It's the way you can enable a party to represent the case fully. There is no harm in it, and India should consider it.
There is a very old decision of the Supreme Court, 1954, Justice Vivian Bose, and this was an issue which arose in that decision. But there it was a lawyer who had accepted fee on a champerty basis, and the Supreme Court actually says that when you are a lawyer accepting fee on a champerty basis, that is clearly illegal. But the Supreme Court in para 11 of that decision actually goes on to say that the question whether a party who's litigating whether he can be funded or not, that's a matter of agreement between two parties, and that is something which could be allowed. While the Supreme Court left that point open, the Supreme Court actually did go on to say that that's something which could be allowed. Now, if you look at the CPC, if I'm not mistaken, Order 25, and certain states have brought in changes, their own tweaks to that order. And Maharashtra at least has brought this in, where Maharashtra requires any person who has funded litigation to be brought in and made party to that litigation, which actually implicitly applies that third-party funding is not to be looked down upon.
Sorry, once again, I think Prakash is saying something. Prakash, you were talking about
No,
third-party funding.
I just wanted to just add on to what he said. I just want
probably a signal for us to stop, maybe.
Yeah, very quickly add on to what he said, that Singapore has just amended its legislation to allow third-party funding. So in Singapore seated arbitrations, that's allowed. Singapore had a huge struggle with third-party funding, partly because it followed the common law prohibition against maintenance and champati, partly also because as a matter of social policy, they didn't want a proliferation of litigation matters. But international arbitration has been carved out. The reason being that if Singapore did not do that, it would lose its market share. It was, in my view, a reaction to Hong Kong. Hong Kong introduced the legislation first, and Singapore saw that, and Singapore, the legislative process is much faster. So having seen Hong Kong started, Singapore said, okay, we are going to do the same thing, and it leapfrogged over Hong Kong. So the legislation in Singapore was introduced first, and it's now become quite an important part of international arbitration practice. Third-party funding is the way to go. If India doesn't allow it, it's going to put itself at a disadvantage.
With that, hello? Yeah. Okay, so with that, we call our panel discussion to a close. And I still note that Tejas hasn't answered my question as to whether or not reincarnation should be incorporated into justice, keeping in view the time taken in Indian litigations. But thank you so much, gentlemen and ladies, for being a part of this this discussion. And I hope you are taking back, you've learned something, taking back something. I certainly am. Thank you so much.
Thank you, Mozam. Please remain seated. I have a couple of very, very important announcements to make. Number one, we will now take a break. We have concluded the first part of this conference. I hope it was knowledgeable. We would request everyone to please re-register yourselves outside at the registration desk for the hard talk session, which is to follow. Please join us for a drink as well while you register. Importantly, the Chief Justice of India is going to be here at 7:15. I request all of you to please take your seats by 7:15. As part of a security protocol, no laptop bags or backpacks will be allowed inside this room. You can carry your laptops inside, but not the bags. You will have to leave your bags right outside this room. Provisions are being made. They will all be tagged. Please join us at 7:15. Thank you.